licensing this morning. We'll get started with roll call and just feels odd because I know who's here, but let's just go through it. So Aaron Longacre, Amanda Bollinger, Rod Hall, and Carol Lear will be joining us after she's done some things that she had to take care of this morning. In order to accommodate her schedule, she asked if we could hold off on some of our UPAC revisions. And in light of that, I put them to the top of the list so we get through them. So what we'll do is we will start with R277301, educator licensing by amendment. And Ben, I think you're going to cue that up for us.
I will cue it up by turning it over to Dr. Hyde, if that's okay. This is basically adding a number of, or updating the requirements for a number of our license areas. We can go into those as specifically as you like, or we can just open the floor for questions, whichever you prefer.
Dr. Hyde, do you want to add anything to what Director Rasmussen said?
I would just, Malia Hyde, Executive Coordinator of Educator Licensing. I would just add that the goal of this several amendments are to have some rule agreement with some of our educator preparation rules and also eliminate a lot of bureaucratic red tape in order to make it a little easier for our educators to prove that they're competent.
And can you just address that? How did we do that?
Sure. So for example, for deaf educators, we had a kind of a hole where we had educators coming in from out of state that had master's degrees in deaf education, but were unable to get a license in the state of Utah. And so this allows them to get a license in the state of Utah and also provides them a pathway in order to get their professional license.
Are there any questions from the committee? Vice Chair Bollinger?
Thank you, Chair. Not a question, but there is an amendment that I would like to propose to this committee. We've had discussions previously about licensing specifically for special education teachers, and there has been a change where a special education teacher who is licensed K-12 mild moderate, right? Typically they can teach all the subjects, but currently with our licensing rules, a secondary teacher would also have to go back and get almost like a degree, right? They have to get a whole endorsement in the mathematics, which means they have to go back to college after they've already done 4 or 5 years of college to get a certificate and then take all of these math classes, even all the way up to calculus, to teach secondary 1, 2, and 3. And my concern with that is what has happened in practice is that now these special educators that have to go back and get this endorsement, now they're leaving special education. Because if they now can teach mathematics, why are they going to keep teaching special education that requires all these extra hours and IEPs? And it really is a concern that we don't want to Dr. Height's point, the red tape. It's just some red tape that I'd like to help us eliminate. In addition, when we provide opportunities for these highly qualified teachers to be able to expand what they're teaching, as long as we know that they're competent, then they're more likely to stay in the profession. And so with that, I would like to make a motion that the committee add after line 294, an individual holding a professional license and a license area of concentration in elementary education, secondary education, CTE, special education, or deaf education may earn an additional professional content area endorsement through passage of a content knowledge test or competency exam approved by the superintendent. So this would not just be just for special educators. I don't want to just identify them, but all of our teachers. The wording on this, from my understanding, would then require somebody to have already a professional license and already be endorsed. Dr. Height, was there language that I needed to adjust? This is exactly what okay, perfect. So I would just open that up to the committee to consider.
So I have a question, and this could be to Vice Chair Bollinger or to Dr. Height. 2 questions. One, the difference between a content knowledge test or competency exam. What is that difference? Why are we distinguishing between the two?
Yes, Chair, if I may. One of the differences is that a competency exam can include knowledge or skills. What do they know and what are they able to do? And a content knowledge exam is just what do they know?
And the second question I have is, it says an individual holding a professional license is eligible. How would a non-professional license holder be eligible to take this knowledge test or competency exam without that provision? Like, if that provision didn't exist, could they just show up and take it?
Yeah, so the difference would be is that the language as written in the amendment would limit this option to prove that you have the knowledge in the content area to somebody who is already a trained teacher. So they already know how to instruct, how to apply assessment practices, how to ensure that all students are learning at those high levels. And now we're just saying, and they also know how to do this content area.
No, I understand that, but if that language did not exist in this amendment, that they are required to hold a professional license, somebody could just show up and say, I want to take the competency exam?
Yeah, and then they would get a full license potentially.
Okay, well, then it's a good reason to have the language in there.
Accurate.
Okay, thank you, Dr. Hyde. Excuse me, Vice Chair Bollinger.
Yeah, thank you. And if I can just add that I do appreciate the language in this because we want to acknowledge that these are already licensed professionals. They're highly trained in being teachers. We also want them to know the content that they're going to be teaching. And so by having either a content knowledge or competency exam, that will ensure that this teacher that is going to teach a new subject has that expertise in the content as well.
Thank you. Any other questions, comments? If not, we're ready for a motion, which is on the table. And the motion is that the committee add after line 294, paragraph 10, an individual holding a professional license and a license area of concentration in elementary education, secondary education, CTE, special education, or deaf education may earn an additional professional content area endorsement through passage of a content knowledge test or competency exam approved by the superintendent. All those in favor? Aye. Any opposed? That passes unanimously. And, that's what happens when you take a month off. I failed to do two things. One, I didn't ask if there was any public comment. Okay, and the second thing is, I didn't take the time to have our newest board member introduce herself to the committee and to the public. So I'd like to turn some time over to board member Longacre and tell us a little bit about yourself and why you're here.
Thank you. Well, I'm here because Dr. Hart was promoted and this left an open seat. So I threw my name in the ring and a couple of things had to happen, but that's how I'm here. So congratulations, Dr. Hart. I'm happy for you because that's why I'm here. I'm passionate about education because years ago I had an issue. I went to my local school board and I felt like I wasn't heard. And I got more involved and figured out what things are happening in education. And I want to be that board member where people in District 7 feel like they have a voice. And I can take their concerns here. And I love to serve. And this is another opportunity for me to do that. So thank you all.
Thank you. And I may be a little biased, but I do think that law and licensing is the best committee here at USBE. So welcome. And I mean that because I think we do have different opinions, but I think we're able to talk about a lot of sensitive issues and weighty issues. And even though we may not always agree, we respect the process. So welcome. Let's go to item. Thank you, Ben. Director Rasmussen. So the motion for the rule is that the committee approve R277-301 Educator Licensing Draft 1 as amended on first reading and forward to the board for approval on second and final reading. Any comment? Seeing none, or all those in favor? Aye. And that passes unanimously with Board Member Lear absent. Let's go to R277-303, Educator Preparation Programs by Amendment, and Director Rasmussen.
Thank you. I think I failed to introduce myself at the start. Ben Rasmussen, Director of Law and Professional Practices. Staff recommended bringing this rule forward because of legislation in the recent session, which requires staff to provide support to educator preparation programs when there is low rates of passage for the science assessment for those educators. So they're recommending putting a couple of things in rule. I'll just kind of highlight those for you. First is a definition for what low rates of passage looks like. That would basically mean that if less than 75% of the students are passing the science of reading prep assessment, that's on 48 through 50. And then they've also recommended just adding some language about what the support looks like, which is on lines 171 through 174. The other change being recommended to the rule is just on lines 145 and 146. This allows for a little more flexibility in educator preparation programs, recommending individuals for licensure that may have been in a program for some time. We have staff here who are happy to answer any questions you have on these changes, and we'll open to that.
I do have a question on the low rates of passage and the 75% figure. Just how did that come about? What makes 75% the standard versus 85% or 90%?
We're going to invite up, if we can, Julie Clark.
Julie Clark, P through 12 English Language Arts Coordinator. Thank you for having me. So 75% was just a number determined based off of where the universities were landing with their educator preparation programs and the scoring as we were trying to identify the cut score and just kind of looking at what percentage of students were passing or weren't passing. And so that first round of tests, when we were gathering data, the scores were obviously very low. And since then, they have gone up. And this 75% is kind of around the middle. We would have a few universities that would meet that passing rate, and then we would have some that would not be at this point. And so we felt like that was a fair number to select. But at your discretion, we are happy to look at different numbers and change that passing rate as determined by you as a committee.
So how many educator preparation programs do we currently have in this area?
So we have, there's 9?
Lisa.
Sorry, I believe it's 9, but we'll invite Lisa up. Is it 9? Okay. We're really close with these mics.
So we have 9
If
institutions.
you could introduce
I'm
yourself
sorry.
for the record.
Lisa McLaughlin, Educator Preparation Coordinator. And we have 9 institutions. We would report and monitor programs based on program area. So elementary, early childhood, and special ed. So if you count that as a program, there's probably like 20.
And out of those 20, how many currently would be classified as low rates of passage?
This is about average, so half would be
Yeah.
below
Below.
possibly. I probably should add that special ed struggles a little bit more than other areas in this. There would probably be more special ed programs that would fall below that 75%.
And so you looked at the metrics and said 75% seems to be the
The
middle
fair
point, right? And
middle
so
point,
that's
yeah.
where this definition came from.
Yes.
Okay. Any other questions from the committee or comments? Vice Chair Bollinger?
Thank you, Chair. Just a question on capacity. So with that 75%, what is staff capacity to help support that?
Yeah, so we have one educator prep science of reading specialist. She's in the room with us back here, Sammy Willie. So she would be the one that would be supporting those university programs in the low rates of passage. Another thing to consider is that it does say in the code that it is after 2 years that they would start to receive increasing levels of support. So that first year that they're kind of below and we identify them, it's kind of like, hi, this is your warning call. You have a year to get those rates up, or the next year you would fall into that system of support from where you would be receiving support. We are always here and available to support them. Sammy does a great job already working with, also in SB 127, each university was able to hire a science of reading expert to be on their faculty. Sammy works closely with them to help them design their courses to make sure that they are meeting the early literacy competencies within their programs and that those concepts are being taught. So she does work closely with those universities. She meets with the deans during what is that meeting?
The dean's meeting.
The dean's meeting. And works closely with them as well to keep them abreast as to what is happening with their scores and with their students and really support them. So she is our one. And then of course, Lisa and I are also here too to support.
Just following up with Vice Chair Bollinger's question, I mean, we're looking at half the programs that will need the developing strategies to provide support for preparation programs, right? And providing increasing levels of support.
Yes.
Is one or even a team of 3. These are 10 large institutions with, I would imagine, pretty in-depth programs. Is that sufficient?
I mean, we could always use more people.
I'd just like to know for the record that Superintendent Hart is here and heard that, so.
We could always use more people.
So.
No, but with you know, it would depend on how many actually fall into that program. So this year in December would be the first year that they would be held accountable for meeting those scores. So it is still another year before anyone would need that level of falling into the full system of support. So.
And then if I could, let's just go to line 171. It says developing strategies to provide support for preparation.
Yes.
Do you have a general idea, Coordinator Clark, in terms of what those strategies would mean? Are you looking at just creating some strategies that every institution would fall into, or are you looking to create specifically tailored strategies?
Both. So we would have some, we are looking at, Sammy is currently working on developing this with that science of reading expert, or the science of reading faculty members, so that the universities also have a say in what this system of support looks like. There will be some things that would be like required, like we will come and do some observations, or we will look at your data with your university and do a data dive into what areas are they falling short in the assessment. Is it looking at the phonics? Is it looking at the phonemic awareness? What can we use to help beef up those courses in that, and doing a data dive? And then we do have some optional strategies where it would be up to the university to decide what support do we need to help us move along in this, so that they would work with Sammy in that. So that is currently being designed.
Vice Chair Bollinger?
Thank you, Chair. I do think it's great that these prep programs get support. When I first looked at this, I thought, why is this falling on us as USBE? Then I realized it is in code, right? It's in the law. So one thing I would just mention as a comment is, I mean, this is a starting point, but like you said, Coordinator Clark, that this is new, so we won't even know for sure if we have the capacity till we really kind of get into it. So one thing I would just say, and this may be directed to Dr. Hart as well, is let's keep an eye on that capacity, because if this is coming from the legislature asking us as an agency to do this, and it's putting undue stress on it, or we need more staffing to make this happen, I think it's something worth keeping an eye on. However, on the flip side, I do see value in making sure our prep programs are preparing our teachers and making sure that they have the skills and knowledge needed to make sure our kids learn to read. So thank you for your work.
Thank you. I appreciate that.
And just on SB 127, I have been hearing from some legislators and some from the field about questions and concerns that they have about that particular, the implementation of that directive. Is that you and your team that
Yes.
we would meet with to discuss those?
Yes, that would be me and my team. Yes.
Okay, then I'll be reaching out and I'll invite members of this committee as well. But, the legislature is really enthusiastic about this and they have high expectations. Just want to
Yes.
make sure that we're meeting those as an institution.
Absolutely. I would love to meet with you and discuss some things.
Okay, thank you. Any other questions? If not, we're ready for a motion.
I'm happy to make a motion. I make a motion that the committee approve R277303 Educator Preparation Programs Draft 1 on first reading and forward to the board for approval on second and final reading.
Okay, the motion before the board is that the committee approve R277303 Educator Preparation Programs Draft 1 on first reading and forward to the board for approval on second and final reading. All those in favor? Aye. That passes unanimously. Board Member Lear absent. Thank you very much.
Thank you.
The next item before the board is R277723, the Start Smart Utah program listed as a continuation and amendment. And Director Rasmussen, is that you? Oh, Elise.
Hi, thank you, Chair. Elise Nui, Deputy Superintendent of Policy. This is just a continuation. So just for the public's information, every 5 years, our rules come up for review to make sure that they're still relevant and necessary. And then this committee and then finally the board votes to continue them so that they continue to be law. The only change that we're proposing that we make at this time is just an inclusion with the oversight category. And so that's the only change that you'll see on the draft. Other than that, we're just asking that we continue this rule as we are still using it as staff.
Oh, Board Member Hall?
Chair. Elise, how did you guys determine that it would move to a category 3?
Great question. So the three things that we really look at are what is like the jurisdictions when we look in law, who is ultimately responsible for making sure that the program happens? Because this has to do with our school lunch that is very much in our territory rather than LEA's. We also look at the monitoring and compliance factors. So what do we do to make sure? And there is a lot of financial monitoring that goes on with this program. And then we also look at staff resources. So how many people are available to be, 100% focused on this particular program. And we have a staff member who does this program, in addition to several other things. So a 3 is not our highest, but it is pretty significantly financially monitored.
Thank you.
I see there's some discussion. Any other questions, comments from the committee members on this? If not, we're ready for a motion.
I'll make the motion. Make the motion that the committee continue and approve R277-723, Start Smart Utah Program Draft 1 on first reading and forward to the board for continuation and approval on second and final reading.
So the motion before the committee is that the committee continue and approve R277-723, Start Smart Utah Program Draft 1 on first reading and forward to the board for continuation and approval on second and final reading. Seeing no lights, that we're ready for a vote. All those in favor? Aye. That passes unanimously. Board Member Lear absent. Thank you. Next up, I'm going to, in light of the fact that Board Member Lear is not present and she asked that the UPAC rules be held until she gets here, I'm going to honor that request. We will temporarily move past item 2.8 unless there's an objection. Seeing none, we'll go to item 2.9, R277608, Emergency Safety Interventions and Prohibition of Corporal Punishment for amendment. And Deputy Nui, I think you have that.
Yeah. Thank you, Chair. R 277608 deals with the use of emergency safety interventions. That's things like seclusion or restraint of students. It also governs the use of or the prohibition of corporal punishment. So this is a little bit of background. This rule came to this committee last year in the fall and the winter. And we made some significant changes to the rule. During the legislative session 2025, there was additional changes that were made to law in this area. And so we needed to bring the rule back. We had this rule in committee in June. We had some questions for this committee about monitoring activities, about data collection. And so we took your advice and we went and spoke to the sponsor of the bill and got some feedback from her, and the changes and the feedback that we got from her is incorporated into this draft 2 that you see before you today. A couple things to point out. If you scroll down to the very bottom, so one of the things that was required in legislation was that there be a investigative process for these kinds of things. We have here at USBE and in the state several different processes that are already in place, such as special education investigations if there's a teacher who does something that violates those teacher licensing laws, things like that. And so we included that in this rule to point out that if there is a violation of this rule, these are the different mechanisms that will move into place if there is an alleged violation. We checked with the sponsor and she is fine with that. She thinks that that is plenty of investigative processes that will cover any violations of this rule. There's also in code several references to also getting law enforcement involved, things like that, so that we have several layers of investigative processes and follow up for compliance. So wanted to bring that to your attention. The other question that we had for the sponsor was how to collect data. So as a reminder, there are several new data elements that need to be collected anytime that a school uses emergency safety interventions. We are putting those into place to be collected through UTREX through a systematized system starting in 2026, 2027 school year. So we have about a year gap where we're trying to figure out how to collect that data in a regular and efficient way. In speaking with the sponsor, her intention was that we just have fairly regular updates to that data so that we can look and start to see what the patterns are, if there is anything that stands out. Mostly just starting to collect that data. And so staff's decision was to have a Qualtrics survey open that schools can go into, enter every incident of emergency safety interventions with all of the required data elements. And then staff will send out quarterly reminders to make sure that that is updated on a quarterly basis so that we'll at least have that information 4 times throughout the year. But it will also allow LEAs to update it whenever they want to as well. So it'll give them some flexibility to set up their own systems. So those were the 2 major questions that we addressed. That is not in this rule. That will just be procedural and will be sent out through emails and communication with LEAs. It's a lot of information.
No, Deputy Newey, thank you for that. Let's start where you ended, which is why wouldn't we, we just amended Rule 123 to require reporting on several matters. Not all, but several that seem to be weightier that as a board we wanted to measure and track. Why wouldn't we include those elements covered in 608 as part of that? Make it mandatory reporting instead of just procedural. Does that make sense?
I think so. So 123, from what I understand, is for the public to make complaints to our hotline. And so that would be if a member of the public sees a potential violation of our rules or law, then they could report that. And that is still available because that applies to every rule and law that governs schools. And so that is still an option. And you'll see that on line 308 that that is still something that comes into play with this rule if we were to see a violation. However, we don't just want to know if there's violations of law, we want to know every time that the law is also followed. And so that's what that Qualtrics survey, every time a school uses it and follows this procedure, they'll update us so that we'll know how many times this procedure is being used and all of the accompanying data to go with it.
That was, and I'm glad that we're measuring compliance as well as non-compliance. I think
Right.
that's a step in the right direction. Let me ask, when you say that they're going to report that to us, what is that? Are they reporting it to audit? Who is tracking this? How is it tracked? Will it be reported to the board?
Great
Oh.
question. We have our wonderful staff here. We have Chrisanne and Ashley. And they can explain a little bit more about how that is going to be set up.
Hi, Chrisanne Lewis, Student Services Coordinator. So we are in the process of developing that data collection right now. We are developing that Qualtrics survey. What we are envisioning at this point is once a quarter, pulling that data, looking for abnormal patterns, looking for any red flags, anything that stands out in those patterns on a quarterly basis so that we can then provide technical assistance and support to the LEAs as needed.
And I'll ask the committee, is there any reason why we would want to require that information to be provided to the full board, whether or not there is data indicating issues? Do we just want to be aware of how many times these interventions are being used, or no? Thoughts from the committee? Vice Chair Bollinger?
Thank you, Chair. It is nice to have that information. I think that if we can have access to that information at any time, that would be great. What I would like us to know is if there were some abnormalities or high frequency usage at specific schools. And I know when we met with the sponsors, well, that was really her reporting concern, right? They wanted to know if somebody was overusing it or was being used really frequently at a specific LEA, that then our agency looks into that a little bit more, trying to provide some support if needed and or retraining. So I don't know if I answered your question. I think there's wisdom in having that data. I don't know about a regular report on it, but I would like to be notified as a committee if there are some abnormalities in that quarterly data.
And I'm assuming you'd be okay providing that data to the full committee if you come across that.
Absolutely, of course.
Thank you. Board Member Hall?
So we're going to all these lengths to be able to track the data with the Qualtrics survey. And is this a system that most LEAs know how to use? They know how to use Qualtrics. They're familiar with it.
Yeah, this is a data collection system that we use for many other things throughout USBE. So I would venture to guess, districts and LEAs are familiar with that.
So this wouldn't require any additional training on how to enter this information into there?
Generally not. I mean, there may be people within the districts that need, or LEAs that need additional training, but there are people within all LEAs that know how to use it.
Okay.
Any other questions from the committee? Vice Chair Bollinger?
Chair, if I
Oh,
may, I apologize. Just to answer your last question, there is also we are required as the board, you all are required as the board to submit an annual report of this data to the Ed Interim Committee, and that will come to you before it goes to the Ed Interim Committee. So there will also be an annual update from here moving forward.
Thank you, Deputy Nui. Vice Chair Bollinger?
Thank you, Chair. Just a couple of questions on the Qualtrics. So you were mentioning that, so we are going to ask the teacher to fill out the Qualtrics survey for every incident. Did I understand that correctly?
Most likely it would not actually be the teacher who's filling it out. The LEA would designate someone who does that data entry. So in many LEAs, everybody's going to do it a little bit differently, of course, but in many LEAs, they have a data entry clerk or an administrator or someone who is responsible, who collects the data and then enters it in. So it most likely would not be individual teachers.
Okay, follow up if I may, Chair.
Please.
So if the district already has a system set up where they're reporting it to their ESI committee, then they could continue that and then have just as long as it gets reported to USBE for every incident separately. Is that?
Yes, that's correct. So they could, the district, the LEAs could choose to report as each incident happens or they could choose to collect all that data and then enter it once at a quarterly basis. But it has to be for each individual incident of an ESI that happens. They can't report aggregate overall data.
Perfect. And follow up if I may.
Please.
How is the districts or the LEAs, the schools, getting the information back from the Qualtrics? Do they get a copy of everything that's been returned, or do you guys give them a report of what has been reported from them so they can make sure that they're meeting that requirement?
So we're still working on that a little bit, but Qualtrics does have the option for whoever is entering the data to then get that data sent to them, get their responses sent directly to them after they enter it.
Okay, thank you. And then one other question, this might be to Deputy Superintendent Nui, maybe. So one of the things we've talked about before, I think I was on line 215, where it says a school employee may not use seclusion as an intervention, but yet we're filling out emergency safety intervention forms. And I know that there's some talk about potentially working on this for a kind of a cleanup bill. So I would just bring some attention to that. If we're saying we can't use it as an intervention, yet it's a safety intervention, I just think that adds confusion. I don't think that there's anything we can do to address that today, but just something that I would like us to continue to watch and see if we can kind of clean that up in the future. Thank you.
You know, I do have just a few thoughts on this. I thought that we had put in the time of 30 minutes. Can you just point that out in the rule?
Excuse me, sorry about that. It is on line 220 for seclusion, and then it is also on 192 for physical restraint. Thank you.
I see that. Thank you. So my question, if we could just keep those two sections in mind. I had a school reach out, and their concern is we put someone into seclusion or follow an ESI procedure. The 30 minutes is exhausted. The parent still has not arrived at the school. This is the example they gave, and they said the parent's still 10 minutes away. Walk me through that process. If the school still doesn't feel that the student still poses a danger to self and others, the 30 minutes is up. How does that reassessment look? Do they have to bring the student out of seclusion, restart the process? Is it just following? No, they can keep them in seclusion. Could you walk the committee through that process of how that would look?
Yeah, so just with a little bit of context, on line 188 to 189, it does clarify this a little bit for physical restraint. We do not have the same language in this rule in the same way that we do for seclusion. But the language says that they would need to stop, release, and reassess. So in the case of that physical restraint, which is where that language is, they might release the student briefly from that restraint, reevaluate the situation, and then restart a restraint if needed. And the idea of this is, of course, we don't want them just continuing a physical restraint when the student doesn't need it, just because the parent hasn't arrived yet. But we also want to make sure that the staff who's there have options if it's unsafe to release that student at that point. Did that answer your
But yes,
question?
that's for the physical restraint, but the seclusion, it says 30 minutes per occurrence. So I guess there's a couple questions. Does the occurrence mean you put them in seclusion, that 30 minutes runs? Is that the occurrence that we're measuring?
Yes, correct.
So it runs for 30 minutes. What happens then? The student still poses a danger to self and others. The 30 minutes is up.
What we recommend is that they stop, release, reassess. So if in the case of a seclusion, they would open the door of the seclusion room, reassess the situation. And I'm not talking a 15-minute reassessment. It's a brief reassessment, and then they could restart that seclusion if needed. But again, that language, just to clarify, is specifically related to physical seclusion in this rule. Sorry, physical restraint. I said physical seclusion. Thank you.
So the release portion would not apply as currently outlined in our rule. The reassessment would need to take place.
Yes.
Is that correct?
Yes.
The other question I have is, has to do with our definitions of immediate danger. And that's on draft 2, lines 55 and 56. So the last time this was before the committee, we included language in lines 52 through 55 that talked about immediate and significant threat, because we not only wanted to measure time, but the velocity of the threat, like the intensity of the threat. This was added the same as immediate danger as used in 53G 8301. Well, when I went to 53G 8301, they do use the phrase immediate danger, but I never saw a definition for it. So if we're saying it's the same definition, there is no definition. So what I would like to propose, and I just want to make sure this comports with what you believe are best practices, would be that, and do you have this in front? I just want to make sure you can see it. So on lines 53, well, I guess starting at 52, it would say immediate danger means the imminent risk of physical violence towards self or others, or other physical behaviors, and just continue it through.
Yes, if I'm understanding your question, we feel like it would be appropriate to use immediate danger as the primary phrase, I guess, that's being used throughout this rule, being used throughout the LRBI or other documents.
And do you have any objection to using the definition that we have outlined in lines 52 through 55?
No, we don't have any concerns with that.
Okay. With that, do we have a motion queued up? If not, I can.
Can I just
We-
offer
we-
one bit of context to consider as we're doing this, is that term immediate and significant threat was included throughout the LRBI and other accompanying documents. So if the board does decide to go in that direction, we would just ask you to consider that we would be able to change that language in those other documents as well, just to make it consistent and more clear.
I mean, I don't have any objection to it, but I also don't have that power. So,
Those aren't before the committee today.
right,
That's my question, is procedurally,
is that?
no.
I'm a little
Board
late
member.
to the party, but it makes me nervous to just say change it without looking at the 200 pages of the LRBI manual and seeing how it's used exactly. I'm maybe too much of a fan of doing immediate and significant threat or immediate danger or something like that, that combines the two, so that the readers of the LRBI manual aren't misunderstanding. So I don't know if that's too many words. I mean, it is too many words. It's not ideal, but is it better than trying to decide today if every single phrase in the LRBI manual is the right phrase?
Can I add something
Please.
quickly? So
Yes.
Ashley Lauer, behavior specialist. So I will say that in the LRBI previously, immediate danger was the term that was used. There was some guidance that we were given to change that term to immediate and significant threat. So I think it would be okay to change that back if we had the ability within the process to do that.
Yeah, it's just that immediate danger was never defined. So we were putting a term in the LRBI and throughout rule where there's no existing definition. So I'm just going to focus on this rule. And if you come across something where it doesn't comport, bring it back to the committee or let the superintendent know and they can proceed. But
And then you're saying you don't want it changed. It would be your preference not to have it changed in the manual, despite the fact that we're now.
I'm just
using a
gonna,
different
I'm
phrase.
making this motion for this rule, and they can continue to use immediate,
Threat.
right. And if they come across an instance where it doesn't work, then they're free to bring that back before the committee or the full board.
Which will never happen because that was so miserable.
Oh,
Okay. Just wanted to clarify what you.
Could I offer a thought that might,
Absolutely.
I'm wondering if we change that back and use the immediate, so and I don't remember the exact lines, but we just switch where immediate danger is the term that's being defined and the immediate and significant threat as it is used in code is it says the same as immediate and significant threat as used in 53G 8301. That may allow us to use those terms interchangeably so that the manual can stay with the immediate and significant threat and the rule has immediate danger, but they kind of become interchangeable.
Can I make a suggestion?
But-
Could we change that definition just to be immediate danger or immediate and significant threat means?
Yeah,
Then you can use them interchangeably?
yeah, I can. Is that what you were saying? Oh, sorry, Carol. Yes.
That didn't come across that way to me.
Well, you mentioned LRBI, so we have to make everything super complicated. That's, yep.
That's a great idea. It's a lot more words, but it's obviously, yes. Yes.
By amending line 56.
I'll do it, Ben. Thanks, Ben.
And is it line 56 or would it be line 52?
Oh,
The committee amend line 52 by,
52, apologies.
yeah, that looks right. That's Deputy Newey, that looks,
One question for the maker of the motion. So then line 56, where it references back to the code, should we strike that as well since we're defining both terms in the same, right?
line 56.
so
yeah, would
also
be deleted.
striking.
Yeah. And if you want to add the language about replacing, you can, or I would just defer that to staff.
Do we want to replace throughout the rule? Sorry, I should talk in here.
I'm sorry, can you clarify that for me?
There were instances where immediate significant threat was used. We could use immediate danger instead. And I can accept that as a technical change, or if we need to include it in the motion, I'm happy to do that as well. And so if I could just see the motion when you're done. Liquid amendment. Any discussion to the motion? I think we've mostly had that. Okay, I'll make that motion, and the motion before the committee is that the committee amend R 277-608 draft 2 by amending line 52 by adding immediate danger or in front of immediate and significant threat and striking line 56. All those in favor? Aye. Any opposed? That motion passes unanimously. Thank you. Okay, let's proceed as follows. Is there anything else that you?
Chair, if I may,
Oh,
I
yeah,
I have
do.
another amendment, actually, I would like to make.
Yes.
Since this intervention thing is just weighing on my mind, I appreciate the support from Deputy Superintendent Nui. Just to clarify on that intervention, so on line 216, just to clarify that it can be used as an emergency safety intervention, but it's not supposed to be used as a behavior intervention. So I would like to make a motion that the committee amend R277-608 draft 2 by adding behavioral in front of intervention in line 216. Is it 215? I mean, in 215. That's okay. Thanks. 215. Thank you. So that way, that just helps us clarify, right? That's as much as we can for now.
Any discussion to that did you read, was the motion read? I guess not. So the motion before the committee is that the committee amend R277-608 draft 2 by adding a behavioral in front of intervention on line 215. Any discussion to that motion? Seeing none, the motion before the committee is that the committee amend R277-608 draft 2 by adding a behavioral in front of intervention on line 215. All those in favor? Aye. Any opposed? That motion passes unanimously. Vice Chair Bollinger?
Thank you, Chair. Just one other clarifying question, if I may, to staff. I've had a few individuals from LEAs reach out and ask questions about lines 232 and 233. So this is explaining that if a student's placed in seclusion, the school or the school employee shall notice or shall provide notice immediately and not to exceed 15 minutes after use. The concern they've shared is that when you're in the middle of a crisis situation, they don't feel like it's realistic to all of a sudden go and notify parents. I mean, obviously, we absolutely want to make sure that we're providing notice to the parent and the school administration. From my understanding, the way this is worded is we want to basically do it as soon as possible, but it could be up to 15 minutes after. So if it's not safe to do in the middle of, or if there's not an additional person that can go and help notify a parent or an administrator, that it could be up to 15 minutes after. Is that a correct interpretation?
Yes, we feel like that's a correct interpretation. And just as a little bit of context, this does allow a little bit more leeway than the previous versions of the rule, which stated that it would, if the emergency safety intervention lasted longer than 15 minutes, it had to be immediate. So that would be during the middle of the emergency safety intervention. But yes, this does allow them a little bit more time.
Just one other clarifier too. We took that language directly from that was adjusted in SB 170, which is now 53G 8301. So that language does come from there as well. It was specific to parents, but it made sense to have the notification of the administrator and the parents at the same time.
Quick question. What if you can't get a hold of the parents? They're at work, they're not answering their phones. Do you go to their emergency contact?
That is a decision that each LEA would need to speak with their legal counsel about. But generally in practice, that's what we're seeing.
So, Board Member Leader.
Similarly to that question, does an attempt count? It seems to me there used to be some language about an attempt, but it doesn't seem to be here anymore. So does that count? What do you do if there are several attempts and you can't reach anyone?
So this language specifically is about just the notification. And so as you know, it could be, we would try email, we would try phone call, we would try several different attempts to notify. And of course, we're still going to care for the child and make sure that the child is getting what they need while we're continuing to try to reach the parent.
Yeah. That's right. I remember reading this, having this question and remembering that it's only notification. And so you don't necessarily, I mean, ideally you don't leave a voicemail message, but there are ways to notify that don't involve actually talking to the person.
Yes.
Great. Yes, that's a good reminder. Thank you.
Any other questions before we vote on the rule? Seeing none, we're ready for a motion.
On the whole rule.
Yes.
Let's see. I move committee approval.
Okay, the motion before the committee is that the committee approve R277608 Emergency Safety Interventions and Prohibition of Corporal Punishment Draft 2 as amended on first reading and forward to the board for final approval. All those in favor? Aye. Any opposed? That motion passes unanimously. Thank you. Okay, so we're going to move on to the item 2.10, amendments to board bylaws, Article 4. This application is being brought by Board Member Bogus. And as a board member, I've invited her to speak to her request for amendment. Yep.
Very weird.
Thank you. So I believe this was brought by Member Carey.
Board Member Bogus,
Breeden
if you could just
himself.
introduce
Oh,
yourself.
my name is Board Member Bogus. I serve District 8 on the Utah State Board of Education. This is actually very simple. It just removes the abusive language and the authoritarian language from Article 4 of the member ethics section. It makes some clarifying things, some grammatical changes, and ensures that we have a fair and sporting process, and that when and if we issue disciplinary action, it is because there has been an actual violation, not ruffled feathers, not consternation, but an actual violation of the law, board policy, or board bylaws. And so with that, I would take any questions that you have.
I have a couple, just let me get it a spot.
Sure. In the meantime, can we go to Vice Chair Bollinger?
I
Okay.
didn't see that she was so much. Thank you.
Vice Chair Bollinger.
Thank you, Chair. And thank you for being here. This is helpful to have you be able to answer some. So one of the questions I have on lines 22, 23, and 24. The wording before, so the way it's changed is members may not engage in a manner that causes legal harm or risk to the board. Previously, the language talked about not acting in a way that may cause legal harm. So with this, can you help me understand when we say that, who is going to determine that? Is that going to be just after the fact? So if it did cause legal harm?
Well, I think that is the reality. We can't, I believe it to be extraordinarily unethical to sanction or issue some sort of disciplinary action for possible harm. We can't go into thought crimes and all of the crazy, otherwise we're just in authoritarian states. And people will say, oh, that's legal risk, but really the First Amendment is very clear. And as an elected official, I would argue that you need more protections under the First Amendment, not less.
Thank you. Is AAG Bill available to?
She is. Thank
would-
you, Vice Chair Bollinger.
Yeah, AAG Bill, can you help us understand with the ramifications, what would be the risk or changing that language? I would just love to have your insights on that, please.
Sure. So I would have some concerns with that change, kind of for the reasons of the question you were asking. The change to say something that members may not act in a manner that causes legal risk or harm. There's no standard for that, right? There's no cut and dry, yes, this caused legal risk, or no, it didn't. So the the language that's being removed, that's as determined by board leadership in consultation with legal counsel, that's kind of legal counsel's job, right? Is to analyze what's causing legal risk to the board. We might have legal risk. We might have risks of lawsuits. We might be getting demand letters, cease and desist letters without actually being sued. So taking away what may cause legal risk or harm as determined by counsel is a much different standard than what actually causes legal risk and harm without a definition of what that is.
May I respond to that?
Yeah, yes.
So I would argue that if we're getting demand letters, legal risk exists and that causes would be the appropriate language. Because if we're engaged in some sort of interchange or discourse with legal counsel or other entities writing letters to our agency, we've already entered the after effects of that.
Oh, sorry, Board Member Lear.
Well, I tend to side with AAG Beal primarily because she's our legal counsel. But I also think that it makes sense to, well, let me say something different. I had another thought about leaving the may in there that I prefer, and that is that it sets a higher bar for board behavior, board member behavior. And I very much respect the First Amendment, and I absolutely think that board members should speak their minds clearly and directly and have that right. But I also think that they have a very strong duty to integrity and to respecting the board's resources and weight. So I think that when you say the board member may not act in a way that may cause legal harm, that causes the board member to be more thoughtful and more careful. And I appreciate that, in addition to the legal concerns expressed by AAG Beal.
I have a question. Since Board Member Lear brought up the First Amendment, I want to talk.
Response to Christina.
Oh, are you done, Carol? Like, did you? Oh, okay. This is line, and I'm sorry, my copy pages got cut off, but this is section 11, part B. And it begins with members may express personal opinions on public education issues, legislation, and areas of concern. And then it says individual members shall state, meaning it takes discretion away, right? There's an obligation. Individual members shall state at the outset of their comments or statements about public education issues that the comments do not represent the board's official position. I understand the objective of that language, but I am concerned that as members of the board, we don't lose our First Amendment rights. And this forces us to say things that it just forces you to say things. And so I have a concern with that requirement. And I've also seen it weaponized. When I was first elected to the board, there were people who attended meetings just to see if you gave that statement and just waiting for you not to, so it could be reported and then start that process. So I see the wisdom of it, because I certainly don't want anyone to leave the impression that you're speaking on behalf of the board. But I think in most instances, that's a given. I see Board Member Leo cringing, but I do think that, when you speak in public, you don't, in my experience, most people I don't think you speak for the board. But by requiring us to say something, I think intrudes on that area of free speech. It's a small requirement, but I just worry about this. You forget to say those magic words, and all of a sudden you are in violation of one of our bylaws.
If I may, member.
Oh, yes, please, AAG Beal.
So I think if you read that in conjunction with 11 subsection A, once the board has voted on an issue, the vote is the official position of the board. I think that subsection B is really narrowly tailored to making it clear that if you're commenting on something that's already been voted on as a position of the board, that you as an individual board member are notating that your opinion on that position isn't the position of the board as it's been voted on. So I think it's really narrowly tailored to that specific situation where it's something that's already been voted on by the board, but you might have a different opinion that you're expressing, and clarifying that your opinion in that situation is not the board's voted on position. Since you're all
So for instance,
representatives of the board.
understood, but like, so for instance, you're giving a speech maybe before the public, maybe you're meeting with a group of legislators. And, you know, it comes down to Utah fits all. And the board took a position on Utah fits all 2 years ago. I mean, in a way, it's unfair because if you don't have that institutional knowledge, you wouldn't even know what the board's position on that was or wasn't, because you weren't here for that vote or for that exchange. Again, I see the wisdom of it, so I could go either way because I understand the importance of it. I think in many ways it's almost more important for leadership because they are meeting with one-on-one sessions with, you know, other legislators who, because of their position as leadership, may just assume, right? And Vice Chair, this isn't personal to anyone in leader, but just generically, there's just that, oh, well, Vice Chair Bollinger is in leadership, she's saying this, and they just assume it. So I almost feel like if we're going to keep this, it's more important for leadership than the full board, but I go either way on it. So I just wanted to know, and AG Bill, I appreciate your input on it. I'm just going to think about it. I don't have a motion on it, but just an area of concern.
Sure. Thank you. I appreciate it.
Thank you. Any other?
Joe,
Oh,
I have it speak to
oh,
that. And I'm working on controlling my body language. So just so you know, it's a 12-step program. It's a try, I know. And maybe I should give up at my age, right? I'm the worst lawyer ever that does not do what you're supposed to do. I do, however, have strong feelings about this. I think some board members are more well-connected with legislators and legislative leaders than others. And you may be very personally, or some may be very personally connected and believe, oh, of course, they would know that I'm not speaking for the board. And I think in more familiar or informal situations that repeating this, it's kind of like when everybody repeats, "Hi, I'm Christine Bogus, and I'm speaking as a board member." I'm just right now, it gets a little repetitive. However, I think when when a board member is speaking in public, I think it's more important to honor that position of the board, our elected position, than it is even to be protective of our free speech rights. Now, that might be an extreme statement, but I think we owe a duty to our fellow board members to be really clear. And I don't think it's much to ask. And I think it's interesting. I had not thought of that narrowing aspect of reading A and B together, but I think Ashley makes a very good point about that. This doesn't apply to every single thing you might talk about or speak to. It just applies to those where the board has taken an official position. And I would say in good faith, it also applies to those where the board's voted and not taken a position. But I think it shows respect for other board members to say at the beginning of remarks, a very short sentence that says, "I am speaking on behalf of myself and not the board." And if you want to elaborate about the board having taken a position 2 years ago or not knowing if the board took a position, I think that's fine too. I just think it shows respect for the board as a whole. And yes, I agree with you. The leadership doing that, I would hope the leadership, our board leadership would never speak. And I've had this conversation with member Earl many times. I think when you're in leadership, you do speak for the board, period, because it's too hard for the public to know when you're taking off and on your leadership hat. But that aside, I respect what this says. I don't think it's much of a burden on our free speech rights. We've taken on an additional role in the public. And I think that maybe trumps what we want to do personally in some cases.
So with AAG Beal's notation that A and B should be read together, maybe that becomes more obvious if, on my copy at least, at the end of A that reads, once the board has voted on an issue, the vote is the official position of the board, period. What if we change that to a semicolon that then led into B, members may still express opinions on public education issues, now there's a concern, individual member shall state, and just to draw that out more that these two are read together. AAG Beal, would that help or not make a difference?
I think it makes a difference. I think that it's one of those minor punctuation changes, but as member Bogus knows punctuation matters. And I think it does matter. I think that's a change that makes sense.
Okay.
I can do that non-substantively.
Okay, thank you. Any other comments or issues? And I do have, on B, this would be 5B. And the change suggested by member Bogus is that instead of saying the committee or board chair, any member may disclose an apparent conflict of interest. And I think that's a good change. Of a member who fails to disclose a conflict. And I don't know if this was intended, but then it says, and take any action described in subsection 5A.
And you know what line you're on there, Joe?
My lines are cut off, but what line is it?
38, I believe.
38? Yeah, 38, 5B.
I see it.
And so the way I read this is, yes, so instead of just limiting disclosure of conflicts of interest to the committee or board chair, what we're doing is empowering any member not only to disclose, but to take any action listed in section 5A. I don't think one board member should have the authority to take those actions enumerated in 5A.
So may I very
Please.
quickly? So 5A simply says that the conflict of interest shall be disclosed. That's all.
Well, then it goes on his little eye.
It's a little tautological.
But the A that's being used here is the little a. It's not the big A.
Yeah, and I understand that, but it references the little a, and it says under the little a, in board or committee work or any matter to be voted upon by the board, a conflict of interest shall be disclosed prior to consideration.
So then,
And perhaps that was an oversight on my fault, and we should just strike that language. Any member may disclose an apparent conflict of interest of a member who fails to disclose a conflict, period.
yeah,
Because you are correct in that it creates a circle. But I don't believe it references down below. That typically is not the way we have engaged.
any other discussion generally before, and I know generally we operate on motion, but in the committee, we're a little bit more relaxed, and I appreciate the dialogue, but just to move ahead, we do have all our UPAC rules to review.
I have one more issue on it,
Please.
in a different place. This would be on line 81. and it says, following due process, the board may reprimand or censure a member for any violation of law. The board may authorize any of, oh, that was her new language. It used to say, a member may be reprimanded. I'm sorry, I wanted to read what used to be on line 76. May be reprimanded or the actions of a member censured for any violation of law. The board or board leadership may authorize the following. And that is now stricken, and it makes it solely the purview of the board. I would argue for leaving the board leadership language in there. And I don't care if it reads following due process, the board or board leadership may reprimand or censure. And let me just explain why, if that's okay. We've seen several instances, and some of us have been involved in them, where a board member misspoke or said something that was wrong or offensive or inappropriate. And my experience has been that board leadership has then, in many circumstances, or at least in some that I'm aware of, contacted that board member, had a discussion. Board member and the board leader have said, well, what do you think we should do about it? And somewhat informally, having heard from the board member, so the person has a right to respond. And then together, they sometimes contacted the person who was offended or the problem area and resolved the problem without it being a public board vote, which I think serves both the board and addressing our internal issues of respect and concern, and it serves the board member who maybe made a mistake. And so I like the idea that leadership may handle that and decide if it's an appropriate thing for the leadership to handle it, or if they'd prefer to have the board act publicly, because the board can only act publicly. Leadership can address an issue more informally and directly with the board member, excuse me.
Would you like me to respond to that?
I'm going to comment first and then ask Board Member Bogus to help us better understand. When I read this provision meaning I equated due process with the hearing that takes place in executive session. I read it narrowly. You're reading it very broadly.
Well, I think you've got two kinds of due process. You've got procedural, which is more the hearing, and you have substantive, which is more an opportunity to respond.
And that's why I'm going to give Board Member Bogus the opportunity. I thought this took place after a hearing when we just do what we do as a board, which is decide what the sanction is. I did not look at that language as being triggered immediately at the beginning of the process, but I'd say
due process can be informal too.
Yes, and I agree. And that's why I'm going to give Board Member Bogus the opportunity to explain what when she drafted this, what were you trying to accomplish?
Well, I think in recent memory, there are many times board leadership has abused board members because they've restricted access to information or responded in a way that was defamatory toward other board members without having all the information. And because the conversation was disallowed, we did not end up in a place that was good for this board. We ended up in a place where we exited executive session and took no action when board leadership had gone bombastic on the whole issue. And so when we don't bring that inside this room and hammer it out and look at all the angles, we end up in a place that does put the board at great legal risk. And I don't think that should be in the hands of 3 people. I think if our audit team, when they receive and filter those, says, hey, this needs to be leveled up, we need to be in a place where that's in this room being discussed by the board. I also think it eliminates the personal issues that exist among board members so that we're not in a place where we have bullying going on. And that has happened in the past where one member went after another member. It just is exhausting. And it is our job to be ethical and upright, but the reality is we haven't always been. And so I do think we need to bring it inside this room. And I did read it as you did, that once it escalates, it comes here. There are things that can be resolved informally, but if we are going to start counseling or remediation, if you will. I mean, even with our employees, we don't sit down and have employee conversation with direct reports to the board without consulting the whole board. Why would we engage in that manner with a board member?
The board member always would have the right to appeal to the full board under the rules that we just amended at 1, 2, 3. So the informal resolution, we try to make that happen, or the opportunity is there. And if the board member doesn't want to avail him or herself of that, they can come to the full board. And I think the changes we made in 1, 2, 3 address some of the shared concerns we had about information flow, getting all the documentation to the board member. And again, I'm good with this if this is, hey, there's no resolution, the board member wants a full hearing, yeah, then the board should decide these things. But I think instead of empowering the board member, you're actually limiting their decisions, because now there will be a full-fledged, we're deciding what's best for the board member and depriving the board member the opportunity to say, you know what, this was a mistake, let's not make a big deal about it. That's the way I look at this.
Well,
Well, I wanted to give board member
Oh.
Bogus the opportunity to respond, because am I missing that?
Well, I would disagree. When our bylaws trump rule, I think we're with the previous language, we're still in a very authoritarian space. And so I would offer that even though that's in a rule, our bylaws need to reflect that we cannot just willy-nilly go and abuse board members. The First Amendment exists, it exists for a reason. And I don't know how I missed striking that language. I think it's absolutely absurd that we should have to state that it's not the official board position. I mean, if I think about it in the context that our Attorney General thought about it, I could probably, and I'm not joking, file 50 complaints tomorrow just based on what I've seen on the internet, which is, come on, man, really? That's what we're going to do? And, I think of everything from the AFP dinners to the Twitter posts of one board member to, and people could probably file complaints against me. If that's how we're going to read that, we've got huge issues in this agency. And I don't think it's appropriate to use taxpayer resources to mediate or adjudicate the opinions of elected officials who were elected to speak on public issues. And I think we are, as a body, we are saying, man, legislators are dumb. The public is dumb. They don't have the intellect to know that these people are engaged in conversations and expressing an opinion.
But the application you filed didn't strike that language.
Well, I thought it did. I really thought it did. I don't know
Okay.
how it was missed, sir.
No,
And that is my oversight, and I have no good excuse, but I thought it did.
okay. Board Member Lear. And then after this, I would like to proceed in terms of motion.
I guess what I come down to is this seems like it needs more conversation. I agree with a couple of these changes. I don't agree with most of them. I think if two of us lawyers are disagreeing about what something says, then it's not clear, and it's legally not clear. And I think that's a greater risk than anything else. So I still believe that there is a role. I believe there's a role for leadership to take care of problems internally that doesn't involve the full board, which should be public. And even if that involves a reprimand or a censure, I still think there's a role for leadership. That's why we elect them. So I think it bears more discussion. I'm not prepared to make a motion, and if there is any motion, I'll vote against it just because I feel like there's not been enough discussion. But I'll leave it to others to decide what to do.
Would you like me to respond to that?
I don't really need a response. I'm just expressing what I'm going to do.
Yeah, I mean, I'll entertain a motion, either regarding the entire submission or just individually on the application. If no one is ready, I have motions, if no one else.
Chair, if I may, if we're just to add, if before we start making motions, if I may, there's one other area that I would like to get AAG Bill's
Sure.
opinion on section 2. That would be line 14. And it looks like lines 14 through 18 have been crossed out and simplified to members have the right to freedom of expression. However, they shall honor the confidentiality of executive session. That piece of honoring the confidentiality of executive session is already required. So AAG Bill, can you help me understand, would there be any risk in striking lines 14 through 18? Is there a reason or benefit to have all or some of that language left in this bylaw?
Yeah, I mean, this is an area where we have had issues arise previously, both with internal USBE employees that have come forward and been publicly identified and asked about, kind of hostile workplace, like what they could do for feeling hostile workplace against board members who have identified them publicly, and then also with students. So I do think there is, the new wording is limited to the only thing is confidentiality from executive session. The old language of refraining from identifying employees in a negative light or from identifying students. That is an area where we have had some legal risk in the past.
AAG Bill, did you have the opportunity, and I'm embarrassed to say because I'm one of the co-signers on this, and I didn't take that initiative to sit down with you and go over this. And that was a mistake. Did you sit down with any of the sponsors of this particular application and have that analysis with them? That you're sharing with the
Fortunately,
committee?
I have not had that opportunity, Chair Carey. I have not. It's something I'd be happy to have a discussion with, if this moves forward to full board, in between now and then, or if it comes back to committee next month, like have a discussion between now and then as well. I'm happy to meet and go over that.
I mean, and I'm going to put this on me. I looked at this as with the legal background, I thought, okay, I have a good understanding of what's happening here, but I don't bring the same level of expertise that you do, and that is your function. So I would feel more comfortable sitting down with you, and I think Board Member Bogus should be part of that conversation as well, just to go through and make sure that legally, just like we do with every other rule, that it comports with our legal obligations to not only USBE, but to the state. I'm going to ask Board Member Bogus, would you feel comfortable with that?
As long as it's coming back next month, yeah.
I think we can do that.
Joe, could I be part of that conversation?
I would invite, I guess we can. There's still 5 of us, as long as there's less than 8 board members.
It's really effective when we did that. I thought it was very effective when we did that on another rule. It didn't quite play out the way that I thought it would, but I thought the discussion was helpful. So I would like to hear what AAG BL has to say in a smaller setting.
And then AAG BL, I know what your answer is, but I just make it formal. Would that pose any problem to you to meet with us in a way that ensures that this gets back on the agenda for next month?
No problem at all. In full transparency, I'm going to be out of office the next 2 weeks, but I can send an email before I leave today to schedule something with you the Monday or Tuesday that I return.
Okay, that's fine. And I'm going to put Deputy Nui, if you could make sure that we get that coordinated in a way that makes sure that this gets on the agenda for next month before the committee. And again, I apologize to Board Member Bogus. I apologize to members of the committee. I should have sat down with legal, just given the nature of the changes that were being made. So the motion before the committee, I'll entertain one.
I move that this policy number,
Bylaws section
Uh,
4.
Article 4 of policy 2, which policy is it, Christina?
It's our
We actually-
bylaws.
Pardon me?
It's our bylaws. There's not a
Oh,
policy.
oh,
number.
that's right. I move that the bylaws subsection Article 4 be postponed until September. The September committee meetings.
So the motion before the committee is that the committee postpone Board Bylaw Article 4 until the September Law and Licensing Committee meeting. All those in favor?
Aye.
Aye. That motion passes unanimously. Thank you. Yeah.
And Elise?
And then I do have a question. I'm reading the cover sheet and it says the board received a request from a board member to remove abusive languages in Article 4, which we have before us, as well as Board Policy 2005 and Board Rule 277123. The only thing that was formally brought before us was Board Bylaw 4. And so it would be my understanding our discussion would be limited to the board bylaw. Okay, thank you. Sorry. Yeah, and as a matter of fact, without objection, let's just take like a 5-minute break. Nope. So 5 minutes, thank you.
That's great.
Welcome everyone back to the Law and Licensing Committee. Next on the agenda are the items that we held relating to our UPAC rules. And we will start with R277-217. Board Member Lear, these motions are coming via her application. So as we did with Board Member, oh, what I said, Lear? Wait, you got. So Board Member Earl, apologies. And as we did, I just as a courtesy, I've invited the sponsor, so to say, to come and just share really just the your thoughts as to why these were necessary, and then we'll just proceed as we would in a regular committee hearing. So with that, Board Member Lear. Geez, Earl.
Hi, Jenny Earl. Let's not get it confused. I know we've got real Earl and Lear, but yeah, let me just share just a couple of thoughts, and then that leads to maybe surgically improving upon. Maybe that's a way of doing this. I know over the last couple of years we've increased the requirements as far as things that are reported to us and making sure that things are being followed through with. And now it's, for me, this is about professionalism in the education community and meeting a standard, especially with our children and for our families, that has that level of professionalism. And so there are things that in here that we're requesting and expectations that that as an educator, there are certain things that as a community we would expect. So some of these things are suggestions I've made, others I've worked with other board members, and then a handful of them are also things that have come from or recommendations from our UPAC what would you say, team, right? That it work on these that are like, you know what, some clarification here would be beneficial. So there might be a little bit of interplay between other individuals, and I'm here for a little bit, and then I've got to get into my committee meeting as well. We were just able to delay it a little bit today. Our agenda is not as heavy, so I'm so glad to be here. So I guess are we starting with 217? Is that? Yes. Okay. So if you want to, I mean, I don't know if we go piece by piece or if there's questions. I don't know what would be the best.
I think we'll just go with committee questions.
Okay.
And if they have something concerning why a particular change was made, I feel they could direct those towards you, but just Director Rasmussen, do you have anything to? Okay. And again, I'm looking more for like the rationale as to the why, and then any real analysis in terms of the law and things like that will direct to Director Rasmussen. So I'll open it up to the committee. Any questions, thoughts? I do have one that I would just like to start with, and that would be on line 60 of draft 1. And that is, I see we use the term young people here, and I haven't seen that in another rule. Is there any objection if we could just change that to our standard? Do we refer to student or students there? Or is young people a term of art that we've used specifically because we're trying to draw a bigger or more narrow circle?
I think it would be fine to change that to students, Chair.
Okay. And then do we need a motion on that, or is that
I can make that non-substantively if that's the.
Any objection to that change non-substantively? Okay, thank you.
Well, go ahead. Amanda, did you? Okay. Okay.
Board Member Lear?
I had several concerns. I'm fine about the consensual sex part on line 30. And this is throughout some of these rules. The one I'm really concerned about is on line 32, engage in a romantic or sexual relationship with a recent graduate. And I I would ask Jenny for an explanation, except it's pretty clear. I don't think there's any
Yeah.
need for, we've certainly seen some of these in UPAC cases occasionally. I saw them years ago. I don't think they're frequent. But here are my concerns with that language, and this applies to the other rules as well. So we don't have to repeat it every time we come to the next rule. First of all, I think recent graduate, though it's defined, I think it's much too broad. And it doesn't say high school. And as I'm recalling the definition, it doesn't say recent high school graduate for one thing, which is a problem.
Board member, could we just, Ben,
We
where
go
is
to
that? Is
definition.
that defined?
If we can go to I
it's
can
in
read it.
UPAC.
So that it's publicly read through. Let me look it down because I think we did try to narrowly focus that. Recent graduate means a student within 1 year of graduating high school
What did say high school?
or within 1 year of turning 18, whichever is later.
Thank you, Board Member Lear.
Thank you. It did say high school, so I appreciate that. But I think it's still too broad, by a long shot. I could give you many examples. Let me just give you a couple. You could have a very big high school, use Alta High as an example, where a teacher who may be 22 or 23 has never met a student, and to take away a right to have a friendship or relationship if the teacher's never met the student is, I think, completely unfair and unwarranted. And we say we love our teachers, but it seems like we continually tie their hands and make their lives difficult. So I think the fact that a teacher never knew a student is a significant difference that I would want to narrow this, or a reason to narrow this. Another example might be a very small town, and I actually saw some of these when I was doing some of Ben's job, where in very small towns, there could be parent friends who maybe have young people of the same age. And so the teacher does know the student and appropriately doesn't date the student until the student's out of high school. And I think that's a very good possibility. And to prohibit that for any kind of relationship, I think is unnecessary and absurd. So if it were narrowed even further to something that, and I don't even know how I would narrow that in the moment, but I think that's another concern. Another concern with the phrase is romantic. What is romantic? Is it holding hands? Is it looking at each other dreamily? Is it, I think forcing it brought to mind, I told Joe this yesterday, it brought to mind the feds who investigated the polygamists in the 1870s and 80s, and they went peeking in people's windows and taking their little brothers and sisters to the sheriff's office to ask what their parents were doing. And that's romantic, says that to me. And kind of moving from that, we're now talking about adults. We're not talking about students, over which I absolutely agree, where we have control. The school is, in a sense, acting as the parent for the period of time they're in the school. And so I absolutely agree. But when the young person becomes an adult, that just becomes prying to me, and it's not any of our business. If there are concerns about grooming, if there are concerns, and I saw some of these, occasional, not a lot of them, but if there are concerns about a teacher grooming a student who's 17 turning 18 or 18 turning 19, then prove the grooming. You don't assume there is grooming, and you don't assume that it's an inappropriate relationship because of the things I've just mentioned. So I think we just leave that alone and let UPAC do its work when grooming is alleged. And that makes investigation necessary and evidence necessary.
Let me, before you respond, Board Member Earl, Director Rasmussen, are we seeing instances of these types of relationships taking place?
As Board Member Lear indicated, it happens. It's not like every day, but it does happen.
Okay, Board Member Earl.
Yeah, and coming from my perspective, this is coming on the heels of just reviewing many hours of human trafficking, grooming content, right? And you're talking about power differential when you're talking about someone who's an educator and someone who is recently graduated or recently turned adult, as if 18 were the magical number, but it is legally, right? So you're talking about a couple
And
of,
out of school. Just so we're clear, right?
what's that?
And out of school. You
Yeah.
mean 18 and out
Yeah.
of school.
Yep. And so I think there has to be something here, and that to say we haven't seen this or this hasn't occurred. And then proving grooming also is a very interesting thing because grooming is trickery. So you're having to find that information. I just think creating some kind of a clear standard. Now, if this needs to be adjusted in some way, but to say, well, we're going to just, I won't share any of the cases, but I'm thinking of cases I do know that we've reviewed. And I was like, it was almost like they were waiting for a student to turn 18. There were grooming things going on before. So I think to have a clear standard is not unreasonable. So especially when you're talking with someone in authority, and it's not just, this is educators, but it also could be a counselor, right? Who has a relationship.
But no authority once they've graduated.
No authority, but they had authority before the student graduated. And I think even in, correct me if I'm wrong, in university classes, there's a period of time when you are a teacher before you can date the person that you have had in your class.
I think that's true anymore. Used to be 20 years ago, 30 years ago.
Yeah, I
think
don't
it's-
know.
I don't, from what I
Okay,
understand,
anyways,
not the case.
the other,
Unless
all
it's a
right.
church university.
And if you want to talk about when does a romantic relationship start? Apparently it's when it's posted on Facebook. So I'm just kidding. That's what my kids told me. It's
Oh.
official now because it was posted on Facebook.
Yeah.
So,
Which
so
I
we can
don't-
put that in there if you'd like.
Well, maybe, I mean, at least it would narrow it.
Anyway, sorry,
Oh.
go ahead.
So, and like I said, we generally run off motion, but I do like discussions that take place. I think it helps the committee better understand all the issues. But if there's no other comments on this, anything else that we
I think
wish?
Amanda had a.
Yeah, I just wanted to add to this, and I do see what you're saying, Member Earl, as far as we don't want to have somebody that's grooming their students to then have relationships with them after. We do not want that to happen. But the way that this is currently wording, this could also be, let's say there's a teacher that's 21 years old and they go out, I don't know, socializing. They meet somebody that is not 18 years old that moved here from Colorado, was never a student at their school, but they have recently graduated. They would still meet this criteria. So I just wonder our scope of authority over personal lives of two adults having relationships.
So does there need to be some clarification in there with their relationship with the student prior to graduation? Does that make sense? So that that
If this passes at all, yeah, I'm sorry, you were speaking. And is that what you were thinking?
Yeah, well, and I'm also even thinking of, I do know of one instance where I actually worked with two teachers that they were married, and the one was the student of this other teacher. They didn't have a relationship at all during the school time, but after she graduated, and it was within a year, but it wasn't like 2 days after or whatever, but later on they did start the romantic piece and ended up getting married and worked at the same school. So in this instance, they both would have not been able to work.
well, yeah, at a point, right? I mean, you're saying that they wouldn't ever be able to have a relationship, which is not true. So we're trying to figure out that power differential and that grooming piece with normal human behavior, right? And where does that come together? So,
Joe, I had one more example too.
Please.
The other concern I have is I actually did see two different cases where the younger person claimed that and it was a she in this case, where she used it both ways. She claimed to the teacher that she was 18 and had graduated from a different local high school. And then when she decided she didn't like what happened, she said, "Oh, I'm really 17. So she lied to the teacher who relied on what she'd said to her. him. And I thought it was unfair to be too harsh on the teacher when he didn't know the individual. She said she was 18 and graduated, and it turned out she hadn't. That's a little bit different, but it could be similar.
It's a lot of bit different.
Well, but it could be similar in that the individual doesn't know that the teacher believes that the student is not a recent graduate of Alta High School, for instance. And yet when you set this standard, it doesn't allow for those knowingly engaged.
So maybe it needs to have something on there
Some
that has
intent.
who had authority over or worked with or something like that. So there is.
And also intent, so that it's not trickery, as you use the word, trickery is not involved, and it can go both ways. So I think that is an important aspect. So it's not an absolute, and it requires intent. So yes, narrowing and intent, and had a previous friendship, not just knowledge, or because a teacher could never have had that student in his class or her class and yet be held responsible for not having any relationship with her or him once.
Well, this doesn't say any relationship.
I know
so.
it doesn't. And I just think that there should be. I mean, because there couldn't be any grooming if they never knew each other.
But certainly if they were in the same classroom, right? If there was a,
If they knew if they were, I think it's hard to, yes.
I'm thinking of counselors, I'm thinking of coaches, I'm thinking of educators that have instructed kids. Those are the ones that I've seen through UPAC that are falling under this category because they do have access to the student.
Well, then had a previous relationship with
Yep.
the student in any form, but I think it should be limited to those and not, I don't like the idea that we assume there's grooming. I think that's a minority report kind of an aspect. We assume they're grooming. I don't think that's true. I think there's many teachers who have healthy friendships with students who are 17 and 18. And I'm not saying they probably don't want to date each other, but if they did, I would not want to assume that there was something inappropriate or grooming going on. And that's what restricting that kind of relationship assumes. And so I would want it to be, I would say, more than a passing acquaintance even.
I don't think it says passing acquaintance.
No, I said, but I'd like it to be more than that, because this says recent graduate. This is anybody who graduated in Ohio or Timbuktu and then suddenly is in Utah and the 22-year-old teacher can't date him.
well, we don't have to assume that this does happen. We know that it does happen. It's not apparently very frequent, but because we know what happens, I think it needs to be addressed. And that's what we'll do today. And this is kind of odd because the definition in the rule is in a different rule. But we'll work that out and we'll get there. Vice Chair Bollinger,
Yeah, Chair, if I may direct a question to Director Rasmussen.
please.
Curious to know, I mean, obviously, if we have seen cases similar to this, and to Member Lear's point of if there was some grooming that would be addressed, do we feel like there's a hole or gap in our current UPAC rules where a teacher could slip through the cracks and have had a relationship inappropriately before that then wouldn't be able to be held under any of our other rules or held accountable under any of our other rules? Or is this really needed because there's a gap in our rules?
I mean, I think there is a gap in our rules. I can think of at least one case specifically where this would have been very helpful and prevented what turned into a really bad situation for the student later on. But this is, I would add, this is modeled after provisions that have been adopted in other states and that are also included in the new model code of ethics that's been adopted by NASDAQ. And that's why staff recommended this be considered.
Do they have a model rule for this?
The language was language that I crafted. I did add some suggested language that you might consider for the definition. If you think the definition of recent graduate is too broad, just something to think about there. Take that for what it's worth.
I would narrow it in addition to in the educator school, because again, if you've got a big high school, the teacher and student may never have met. So I think that is unduly restrictive for both teacher and student. That's a relationship freedom too. That's not exactly freedom of speech, but it's a relational freedom that people are entitled to have. So I think there needs to be some narrowing that includes some previous relationship with the student. I don't know if you say the student was in the teacher's class, because I think you're right, Jenny. It could be a counselor, it could be a coach that's licensed. But a previous relationship would cover that. I don't feel good under the First Amendment about narrowing someone's right to have a relationship with someone, unless there is some definitive proof with adults. I mean, Ben, when you said there was one case, what prevented you in that case from proving grooming just independently of the relationship as a graduate?
Because
Is that okay if I ask him that? Joe?
Please, yeah, please.
in the case I'm referring to, the student had just married the teacher and didn't want to testify against him. Later, there was abuse in the relationship and there were crimes committed.
But
But it
the
was-
student chose as an adult not to testify, which hard to babysit that kind of behavior. So I don't know, do you want us to try and come up with a definition right now?
My thinking is we probably should have started with the rule where the definition is.
I
in
think
order-
you could, I mean, I don't know, but you could probably go back and forth just a little bit, right? So you can, because these things overlap, is my thought. But
This seemed, based on my discussion with
Yeah.
the committee members, this
Mhm.
seemed to be the biggest issue. So
I
my
think I
hope is
had-
that if we can successfully address this,
Oh, I had one more thought about this too. The other concern I have is when there are UPAC investigations involving students and employees, the UPAC investigators have access to those individuals because usually they are part of the school community. If you start dealing with, and teachers you would always have access to, but the other individual, now this sort of your example, Ben, prompted me. We don't have subpoena power. I guess actually you do, but practically it doesn't. Have you ever really used it? How often? Twice?
We issue subpoenas every week.
Well, but
What
they
do you
don't,
mean?
there's no legal penalty for not responding to the
We-
subpoena.
We can take them to court. There's a legal penalty, sure.
And have you ever taken them to court?
Well, no, we haven't had to, but we have.
My point is that this is not a criminal subpoena where it's as easy to bring in an 18-year-old and who has nothing at stake. So I think if that 18-year-old doesn't choose to come in voluntarily, it makes it difficult to fully investigate. So that was another concern I had. But in terms of definition, I think, Ben, you want to go back to your beginning of a definition or whoever's driving? Okay, Jenna, how would you define romantic, Jenny?
well, Carol, I think it's someone who has.
oh, boy. No, that's why we don't do this right there. That's why.
Maybe romance is not as big a part.
Yeah,
of my
maybe it
life,
doesn't mean
you
the
know?
same thing to you that it
Yeah,
means to me. I'm not
exactly.
sure.
But
I'm not
so-
sure.
So is it touching?
If you want to put more parameters around that, I just don't see why we're not going to put something in that's going to protect youth in a way here that, and I agree with you, Carol. I think you're right. I don't think all relationships, and we shouldn't make that assumption. But certainly we should, if we have bad actors, we should find a way that we're able to adequately address that.
Fair
So if romantic is not, we're not able to define what that is, if there's some kind of a,
A relationship that involves touching.
so,
I mean, don't hug, don't
Well,
hug an 18-year-old, even if it's a close
Yeah.
family friend. But
I mean, you can
that's
pull,
better.
yeah.
I just think when we tell a teacher, you shall not, we need to be really careful about defining what they shall not do so that they're not saying, oh my gosh, can I go to a movie with a friend? Can I, that's old fashioned too, but can I be on a picture?
I mean,
on
we can pull
Instagram?
up,
Can I be
give me
together
a
on
few minutes, we
Instagram?
can pull up all the content with the legal content that says this can be pursued under this, and this can be, if you want to do that, if that's easier to do it, just reference code and say, these things do, I don't know. But those are more, that's more criminal code, and I don't know if you want to go that direction either. That doesn't even sound like the right way to
So
go.
you could never criminalize this. This
So
is,
let me,
I know, that's why.
let me do
Yeah.
this.
which is what
Deputy
makes it
Nui, just remind me if I ever want to have a board member speak at our committee, that is not a good idea, regardless of the board member. That was me trying to think, oh, this will work out, but.
Okay, all right.
It might have something to
Board
do with
member
Jenny
Sherry.
and myself.
I know. But let's just, because, you know, we still have several rules to go through. Let's put a motion on the table with a definition. And if no one has one that's operable, and I'm referring to now the definition in Rule 210. So if there's a motion to amend that, if not, I will make the motion following Ben's proposed language.
Could we work on this for a month and bring it back next month? I'm willing to come up with a definition, but I just feel like this is Christina opined about First Amendment rights. This is a First Amendment issue for teachers and for 18-year-olds.
But and that's why I think the urgency is there. The other one concerned us, like, as a board. So I don't think the urgency is the same. This does involve minors. It involves members of the
Doesn't
public.
involve minors, involves adults.
Well, yes and no, right? I mean, if there is grooming taking place prior to
That
their,
includes the grooming.
right. I understand. So let's do this. I'm ready to make this motion unless someone else has.
I'll improve upon this. I mean, that's just not fair. It's not fair and sporting.
So Carol, let's do this. If you want to mentally work on that, we can discuss other parts of unless you're ready to make that now.
Let me work on it for a minute.
Okay, so we're going to move on from this part of 217. Are there any other areas that the committee wishes to address or discuss?
That's a problem. I have other concerns. And that's,
And Carol, you'll have a chance to do it. I'm just trying to. Or Carol, would it be better, just want to take 10 minutes and have you focus on that so we're not discussing this and you have.
I have a problem with line 71. Expose a student, is that?
I'm
And
going to make a motion. If you don't want to take a 10-minute break, I'll just make the motion
No.
on the definition.
let's take a 10-minute break.
Okay, thank you. We'll take 10 minutes and then resume. Thank you.
Okay, Amanda, help me. Okay, so we say. I think it's. Yeah, I wonder if it's. Oh, yeah, I think that's so, but I think there's the element, am I stealing your pencil? I apologize. If okay, so first of all, I think there's the element of knowingly, so that you don't get the situation I did several times what I saw where the girl, and it was a girl and a boy.
Right.
Girl
From a different
saying-
state. That
Well, or a different school even.
Yeah.
In the same county, it was in Cache Valley, and the girl said she was 18 and graduate, and that case graduate, but she could have said she was 19.
Yeah.
And not a recent graduate.
Yeah.
So knowingly, and some language came to me quickly, knowingly engage in. Well,
It's like they they knew that they were a
It,
recent
it,
graduate.
all of these would involve, discussing it with and seeing who you believe. If in the case I'm thinking of, the teacher and this, it's like that you have to prove intent in a criminal situation. So you just have to get testimony and you have to see who you believe.
It's no big deal. I
knowingly-
just want to let you guys know we can hear you online. Not that you've said anything bad, just letting you know.
Thanks, Ashley.
No problem.
Knowingly in a, I was gonna
Okay. We're gonna call everybody back. And let's start where we left off. Do we have a motion on this rule?
Yes, I have two motions.
Okay,
One, and this would be in R 277210. We would change, I move that we amend the definition of recent graduate.
wait, if I could just, if we could call it up, or if not, we'll just find it. Page 249, thank you.
To read, recent graduate means
You made a
a-
lot of progress in that.
well-
It was just, we got to what you had, like that's.
pausing. Recent grad, now you gave me performance anxiety. Means an individual, I guess is what we usually use, it means an individual within 6 months of graduating from high school. We all thought that 1 year was too long. So that would change that to recent graduate.
But would that be within 1 year
Means an individual within,
or within 1 year of turning 18? Like,
no, you really, the point is that it's, that if any student of any age is out of high school and has waited 6 months, then it's not our job to to step in and protect that young person.
And I apologize, you were making a motion. I should
That's
have
all right.
held
You were
until.
clarifying that the rules don't apply to the chair. We know that. So, I kind of garbled that, but I think what Ben has written up there is what we want to say. Recent graduate means an individual. I don't remember the word that was used in the original, but so maybe individual is not perfect, but it means individual within 6 months of graduating from high school, whichever, if you want the preposition or not.
So we have the motion on the table, and that motion is amend the definition of recent graduate to read recent graduate means an individual within 6 months of graduating high school. A discussion to that motion. Seeing no discussion,
Chair, if I may.
yes, please.
Just one comment on the language of turning 18. I mean, we may have an individual that, let's say they graduate high school early at the age of 16, because you can graduate early at 16 or 17 years old. And so with this language, if we left the language in of 1 year of turning 18, whichever is later, that means even if a kid graduated when they were 17, then you're saying until you're 19, there's just nothing. So that's one of the reasons behind this language. We make sure that they're no longer under authority of any teacher with the 6 months.
Okay, so then we're ready for a vote, and the motion is that the committee approve R277. Well, procedurally,
Do you want to share them all?
yeah.
You want to vote on the motion.
Oh,
Okay.
yes, okay.
So, but R277-210 is not before the
Right.
committee right now.
So, but we needed, oh. Or
Okay. Okay. Something about rules not applying to the chair. So, so that the committee approve R277-210, Utah Professional Practices Advisory Commission, UPAC Draft 1. Does it?
Vote on the amendment too, right?
Oh, apologies. I'm sorry. So we have a motion before the board, and that motion is amend the definition of recent graduate to read recent graduate means an individual within 6 months of graduating from high school. Seeing no discussion on this matter, all those in favor? Aye.
Aye.
Any opposed? That motion passes unanimously.
Yeah,
Member
I had a
Carey.
thought.
Just a reminder, can we get a motion on the oversight category for this too?
Oh.
We have one
Oh,
drafted.
Yeah, and let me make that and we'll go to you, board member
Okay.
there. There's also, We'll entertain a motion on the oversight category. Anyone? Board Member Longacre? Would you like
You
to
can
make
just
that
read it
motion?
right there on the oversight category. It's just, it's shaded.
Yes, I make a motion that the committee amend. I think we have too many microphones.
Oh,
I make a motion that the committee amend R 277-210 draft 1 to include an oversight category of exempt.
Okay, the motion before the committee is that the committee amend R 277-210 draft 1 to include an oversight category of exempt. All those in favor? Aye. Any opposed? That motion passes unanimously. Back to you, Board Member Lear. No, I thought you had a, yeah, I thought you wanted it.
just saying graduating from high school, and maybe Ben can speak to this. That include leaving, dropping out, GE. Other reasons that are not technically graduating. At that, because I think that is probably these days more common than it used to be. Yeah, that's probably a better word. No, except the GED requires it. I think officially, officially exiting.
I believe,
Is that not such change?
yeah, let's make it formal. So there's a motion on the table. I'm going to call it a motion to amend. That motion is to amend the definition of recent graduate to read: recent graduate means an individual within 6 months of graduating or officially exiting from high school. Discussion of that motion, just to make it clear on the record, Board Member Leader, could you again share why that language is necessary?
I'm thinking it's. Those rights as those who graduate.
Thank you. Board Vice Chair Bollinger.
Thank you, Chair. And just to clarify, and Director Rasmussen, maybe this is directed to you, but this would still, if a student, let's say, drops out of high school and they're underage, then there are some legal ramifications if they started a relationship already in place, if they start a relationship with a student under the age of 18. Is that correct? Okay, thank you.
So to be clear, the motion, I'm sorry, Board Member
No,
Hall.
it's okay. I had a quick question. So, or officially exiting high school, does that 6 months still apply?
Yes.
Or officially exiting, does that cut out the 6 months? Because when I read that, it says means an individual within 6 months of graduating or officially exiting high school. They could be a week out of high school. They officially exited high school. So
6 months, the way that's written, would apply to
It would
both
apply.
graduating
Okay.
or officially.
Okay.
That's what
Okay.
Any other questions or discussion? Seeing none, the motion before the board is a motion to amend to add or officially exiting to the definition of recent graduate. All those in favor? Aye. Any opposed? Seeing none, that motion passes unanimously. think we can go to the,
217?
well, I think we have to do the motion on 210.
Oh.
Yeah. And the motion is that the committee approve R277-210, Utah Professional Practices Advisory Commission, UPAC Draft 1, as amended on first reading and forward to the board for approval on second and final reading. Any discussion to that motion? Seeing none, all those in favor? Aye. Any opposed? Seeing none, that motion passes unanimously. Back to R277-217. The committee chair will entertain a motion or motions on that rule.
Can we get a motion to add a category 4 for the oversight category on that?
Vice Chair Bollinger?
Thank you. Chair, I'd like to make a motion that the committee amend R277-217 draft 1 to include an oversight category of a 4.
Okay, we have a motion before the committee, and that is that the committee amend R277-217 draft 1 to include an oversight category of A4? Okay, of A4. All those in favor? Aye. That motion passes unanimously.
Okay, for the,
Yes.
and this would be R277-217, line 32. That would now be amended to read, knowingly engage in a sexual relationship, eliminating romantic, in a sexual relationship with a recent graduate over whom, and I'm just realizing now that this only applies to licensed employees. So it would be over whom the, I don't know if we need to indicate, I'll just read it and tell me where license should fit in or not. Over whom the school employee, over whom the educator, that would include, but what about the licensed coaches, counselor, would be any of those? Okay, then licensed educator, over whom the educator had a school supervisory position. Okay, let me try it one more time. Knowingly engage in a sexual relationship, excuse me, with a recent graduate over whom the educator had a school supervisory position. Can I speak to that?
Yeah, if it's done. Yep, please.
So knowingly means that the educator has information that or she is not being tricked or is relying on something that he's told, she's told. So knowingly was to kind of establish the intention, the intentional act that the educator's involved in. And then romantic, our consensus was it's too hard to pin down, and felt like what we're trying to avoid is any kind of sexual relationship. And then we thought that the supervisory position covers some kind of previous relationship. It could be a coach, could be a counselor, could be a teacher. And that also addresses the issue of the teacher that knew the student and still had a teacher-student relationship, which has some weight. So it would cover not just the teacher that is the classroom teacher, but another teacher in the school. And then we wanted to add school supervisory positions so we don't get into the mix of club sports or religious activities or advisors. So that's why all those words.
So sexual relationship, and I agree that the romantic opens up too many uncertainties, but with sexual relation, are we narrowing that? Is a relationship different than activity? Like, are we implying, like, if you're in a relationship with someone that's sexual, that, to me, that means one thing versus
I
an
would,
incident of sexual intercourse or,
well, and I think it
Can-
would be inappropriate.
Can I make a suggestion?
Well, I was gonna say activity. Engage in sexual activity with a recent graduate. If you have something else,
We
Ben.
have a term defined in the definitions of sexually explicit conduct, which lists basically all the sexual things you can do.
so instead of relationship, sexual.
Explicit conduct. Does that sound okay?
Yeah, that's all defined.
How does it, can you read that, Ben?
Knowingly engage in sexually explicit conduct with,
But
I
give-
think she
what-
meant the definition.
Yeah, what
I
is-
can pull it up, yeah. let me find
We're
it.
not testing your reading skills, Director.
Let's see, let me find where the width section is, I'll have to pull it up, but.
Is it in 210?
It's, well, it refers to a code, that's why I'm trying to, consensual sexual activity is where I want to find the definition, sexual explicit. So sexually explicit conduct means the same as that term is defined in 76.5B103. Let me pull that up. The,
Right there.
so it's basically a graphically specific list of everything dirty.
I won't make you read it.
Okay, if we can go back, if everybody's done, can we go back to the proposed motion to see that language? Knowingly engage in sexually explicit conduct with a recent graduate that we defined over whom the educator, and Director Rasmussen, just for the record, when we say the educator, can you put on the record, does that include counselors? Does that include coaches? Does that include?
In my view, that includes anyone with an educator license. So administrator, counselor, coach that has a teaching license, anyone UPAC has jurisdiction over.
Okay, and it's defined that way in our rules?
Yes.
Okay, thank you. Had a supervisory school position, and this is my second area of concern. So how would this scenario work out under this definition? You have girls soccer coach, boys soccer coach. The boys soccer coach sees someone on the female team. They know each other, they interact, and then she graduates, and then if this rule passes, they violate this rule. Would that coach be considered a supervisory position over the female soccer student?
In my view, no.
See, in my view, if that coach is licensed, he has as much supervisory authority as a teacher who's never met the student, but still is an educator at the school. He's still an educator at the school.
Why don't you just say over with a recent graduate from the educator school?
But I think,
Because I don't think you necessarily have supervisory authority over every student at the school.
but I think that's too broad. My problem is that if there's one teacher who's been at the school for 1 year and never met the student that he then wants to have a relationship with, I don't think that should foreclose that if he has no relationship. But if well, I'm kind of arguing against myself and I'm not meaning to do that. But supervisory, I think, applies to any educator. Well, I don't know. Let me think.
So
Chair Carey, I think if that's your concern, I would say that this does not cover that educator, but that's kind of a policy call of how broad or how narrow you want to draw.
Maybe
this.
Amanda has a thought.
if I could, and I think it really does come down to that, right? You don't want to cast the net overly broad. And I would tend to err on, I would rather err on the side of preventing, a potential conduct that we're trying to address in this rule than draw it so broadly that we fail to prevent that. So that would be my bias. But let's continue the discussion. Vice Chair Bollinger?
Thank you, Chair Carey. And I would agree with you. I think that's one of my concerns as well. We don't want to encourage that, like, go ahead and start having relationships with as many young kids as you can. We don't want that to happen. If I may direct a question to Director Rasmussen, given the example that you said that you felt like there was a gap in our rules, what wording would you suggest to make sure that that didn't get through from this current wording?
I would suggest what I just suggested to Board Member Lear, which would be to sexually explicit conduct with a recent graduate from the Educator school.
No.
Yeah, and I think,
I think it narrows it in an interesting way. That is so it's to be right. Because I guess. Leave it, because I don't wanna.
Yeah, I was going to say with that wording of knowingly, right? Once they know that that once they engage in a conversation with somebody, to your point of if they were from a very large high school, they didn't know that student was going to that high school. But once they do know, there's no reason why they should be having a relationship at that point.
That's the sixth one.
so would you be willing to make a friendly amendment, or do you want us to formally? Okay,
I think the knowingly helps me, and also the sexually explicit conduct.
any further discussion on the motion before the committee? You know, I'll just comment and say I appreciate again the work of the committee. I know this is an area of, because again, we're intruding on First Amendment rights of assembly, of speech, but also a strong desire to protect the student. And so I appreciate the work of the committee in making this happen. The motion before the board is that the committee amend R277-217 draft 1 by amending line 32 to read, knowingly engage in sexually explicit conduct with a recent graduate from the Educator school. All those in favor? Aye. That passes unanimously. So there are other areas in Rule 217. So if anyone has a motion, let's have a motion and then we can have discussion.
I don't want to be the only one speaking, but Amanda, did you have others, or Aaron, did you have others?
Just for the record, I want to point out that Carol is using the composition book given out by Civil yesterday. So
I said, anybody who wants to give me their notebooks, I'm kind of a notebook queen. So I have an issue, and I think it's 217 that we're in now. Yes, it is.
Mhm.
Line 85.
yes.
I feel like, and I again, this comes from examples I've heard and concerns I've heard from parents. These are things that a teacher may not, an educator may not. If we get all the way to the top, let me make sure. An educator may not. So then we're going all the way down to line 86, which says, to begin with, discriminate, harass, exclude a student participating in any program, deny or grant any benefit to a student, or encourage a student to develop prejudice on the basis of, if we were to leave that as religious beliefs, I would feel strongly that it should also say non-religious beliefs. I like, even though creed's kind of an old-fashioned word, I think that covers more of what a teacher should not persuade a student against. So I prefer that. I don't know if that was your language or Jenny's. Ben.
That was Chair Carey's language. I have no problem with that.
But
change.
If a student's an atheist, a teacher has no business persuading a student not to be an atheist. And if it's a Satanist, same. If he's a to use, I won't go use some of Christina's examples, but if it's any of those things that teacher has no business encouraging or persuading a student against that. And again, if it says religious beliefs, it should also say non-religious beliefs. So I would just prefer with sticking with creed unless you have a less arcane word to use.
Well, we could stick with creed because religious beliefs is articulated in line 89.
And
that's good.
political or religious belief, right?
And
creed-
I should clarify. I think you actually originally put religion there, and my staff, when they saw that, said this should be religious belief because a lot of the time it's broader than just someone's religious. And I didn't even notice line 89 when I made that change. But so I just want to clarify that.
But creed would cover my concerns, so I don't care if 89 has religious belief because I want students, when UPAC was more my job, I actually saw educators occasionally berating students who were choosing to do certain things after graduation or who were not choosing to do things after graduation. And I think that was highly inappropriate, and we don't want that. So I like creed better. That's my motion.
And the motion is?
To delete religious beliefs on line 85 and use the word creed unless someone has, again, a more.
That would be on 102 as well. We have the same list twice in the rule.
Right, I think so, yes.
So I would have a substitute motion on that. And that would be to leave religious beliefs where it is. And then the second religious belief, put in creed.
Well, you'd have to say political belief or creed.
Okay.
I think then my motion would be to say religious or non-religious beliefs. On line 85. Because I think you can't talk about not having disparaging religious beliefs without also protecting those who have no religious beliefs.
Understood. You said you liked creed, and that's what I left on the table, but now you want, and
Well, I'm
you're free
saying-
to make it. And
Yeah, I'm saying if we don't want to be neutral in our language, then I think that we should include both aspects of that. And creed was a more neutral word, I think, than religious beliefs. And I think teachers should be cautioned about pressing either on a student. Not just cautioned, but directed to not impose either one of those things on a student. So that, then with that suggestion / threat, I would say my emotion would be on line 85 to say color. And then line 85 would say religious beliefs or non-religious beliefs.
so let's do this. We do have a substitute motion.
Oh, sorry.
Right. And so we're at the 2 motion limit. So let's vote on the substitute motion, and then you're free to make the motion that you would like to make. Is that procedurally correct?
Yes.
Okay. So with that, the motion on the table is to leave religious belief on line 85 and 102, and to replace religious belief with creed on line 89 and 106.
Oh, you want to start with my motion? And
No.
then, but your motion.
It's the substitute.
Oh, okay, just a minute. Then Aaron just made a very good point. Do you want to say that out loud?
I think that we should keep or have religious beliefs and non-religious beliefs. I think that's just easier for the public to understand than creed.
No, it may or may not be. The substitute motion, and I'm going to make the motion, is to, as it says there, replace political or religious, excuse me.
Then that's later.
Yeah, and then you can make that motion.
And I think we're maybe talking past each other.
Mhm.
So let me think about what's on the board for a minute. That's right. Oh, okay, so if we wanted to do this differently, then we'd vote this down and go back to it. We vote no on this. Just say political, where it just be. Oh, here, none.
Can we not be too wordy enough?
No, that's a very good point. Easy to understand. But I'm just trying to decide what we do in light of this motion. Yeah, see, I think I'd like it, I think I'd like to tweak.
Chair Carey, may I direct a question to you?
Sure.
Can you just summarize the reasoning behind this wording in your motion, please?
Yeah, I think that, we have a recent executive order by the administration saying that, people should be able to exercise their religious beliefs more openly in public places. I support that. And I think that this amendment executes on that directive.
Can I ask you a follow-up question?
It's not too hard.
I think it's pretty easy. As a education leader and as an attorney, do you believe that if we protect those religious beliefs, we should also protect non-religious beliefs?
I do, and I think it's inherent in protecting religious beliefs.
So you need to say one and not the other.
I think it's comprehensive.
Okay, that's
And I think by saying non-religious, you're actually strengthening the non-religious over the religious. That would be my position.
okay.
And again,
I think
I'm giving time for the,
it's just a helpful background. That's all.
Yeah.
You don't need to defend your
religious beliefs.
explanation or your religious belief. Okay,
And again, I left more time before taking the vote because I wanted to make sure everybody understood what's on the table.
okay, I've got a different, well, you know what? Let's go ahead and vote.
Okay, so the motion on the table, it's the substitute motion to leave religious belief on lines 85 and 102 and to replace political or religious belief with political belief or creed on lines 89 and 106. All those in favor, and let's just take a voice vote because it doesn't appear that it'll be unanimous. Board Member Lear,
Pardon me, what are you doing?
a voice vote.
Yeah, oh, I know. I was just pausing. I'm an aye. I'm fine.
Board Member Longacre.
Okay, I'll be an aye.
No, there's no.
Board Member Bollinger. Board Member Hall. Okay, and Board Member Cares and I, that passes unanimously. Any other motions or discussions regarding this or any other issues in this rule?
I think so. Let me just look at my notes in my little notebook.
Well, Board Member Lear is looking, I have a motion or may have a motion on regarding line 137.
In this rule,
Yes.
we're kind of switching back and forth between.
Yeah, this is rule 217.
Let's see.
And I just have a question for Director Rasmussen first. This particular, we're talking about required conduct for an educator. That's the section that this falls within. And then on line 137, instead of making this as broad as possible, we seem to be really focusing in on a few behaviors. And those few behaviors would be, it has to be hostile, intimidating, abusive, offensive, or oppressive, creates that kind of environment. why wouldn't we try to make that more expansive when we're talking about the standards that we hold an educator to?
Well, I would argue that is pretty expansive, and I think we use that language because those are generally defined, or they're legally understood terms, hostile environment or abusive environment. But I mean, I think that encompasses quite a bit. I'm not sure what you want to add to that to make it more expansive, but I would argue it's pretty expansive already.
I'm glad you asked, because I'm thinking on line 137 before the word hostile, would it be, I was thinking of adding the word inappropriate, comma, hostile, intimidating, abusive, to make it more inclusive.
I'm not sure I understand what an inappropriate environment is. I mean, I mean, the other things I think are more easily understood in my view, but I mean, I'm open to it if that's a policy you want to promote. I think would, I don't know if I necessarily understand what that would be in this context.
And so maybe the issue is with environment. Why wouldn't we just say, look, if you act in a hostile manner, an intimidating manner, abusive or offensive or oppressive, why do we add that additional, well, yes, they were hostile, yes, they were abusive, but it didn't create that environment. It's almost like we're requiring the conduct plus.
So are you suggesting just putting a period after employee and striking the rest?
No, I would say put a period after oppressive. And then we would have to change it where should have known.
Well, that wouldn't make sense, because you're saying that may result in a hostile what? An intimidate, you see what I'm saying? Intimidating what? Abusive. Those are adjectives that are describing environments. You'd have to replace
Okay.
environment with something.
Understood. So this will be my motion. And the motion would be leave line 134 the same, 135.
You've already covered inappropriate language there.
So how about we do this? On 134, it says mitigate and prevent harassment, intimidating, abusive, offensive, oppressive, and then inappropriate language or conduct, period. And then we would strike the rest of line 135, 136, and 137.
And you'd put all the
Right, we would put all those descriptors.
modifiers
Right,
along with,
between
Added.
harassment and inappropriate. So as it says here on line 134, take prompt and appropriate action to stop, mitigate, and prevent harassment. And then I would add hostile, comma, intimidating, comma, abusive, comma, offensive, comma, oppressive, comma, and then just leave the rest the way it is.
no,
Are we writing this in context so we can see it?
I hope so.
take prop and it's so, well, let me throw in an idea and you keep processing how it should read.
Well, let me get, yeah, because just for the, so we're all on the same page, just want to make sure this is right. Hostile, intimidating, abusive, offensive, oppressive. Yeah, and while there, we go ahead, Board Member Lear.
My concern with appropriate is the others have a certain element of subjectivity, but they're common, it's common language for Title IX concerns. Appropriate is even more vague. I am troubled by a teacher having to, I think a teacher would always do that, given a teacher's responsibilities and training. But I think being judged after the fact about whether it was appropriate is much harder than judging the other things. And I actually like the word environment because at the end, because that again mirrors the Title IX concerns and it's just not throwing it out there in a general way. You can have a hostile word, but if it doesn't create an environment that is hostile, then it's less serious. I think we saw some cases like that yesterday, where if the words are inappropriate, sure, they shouldn't do it, but the serious level of discipline comes when the environment is changed.
And I just draw the line in a different spot, right? I think that we already cover Title IX and Title III in line 129.
Maybe we don't need this at all then.
No, what I'm saying is you do, because if we leave the violations way up here, we're missing an entire swath of violations that are unaddressed in our rule. So really the way we had the rule currently constructed, we're basically saying this is what Title IX prevents, and now we're going to say what Title IX prevents. But this section is not called prevention of Title IX infractions. It's called required conduct for an educator.
And I'm more talking about the well understood nature of this as opposed to inappropriate.
I understand, and I want to be more inclusive. I want to make sure that it's not just abusive conduct, because to me, you're right, abusive does rise to a certain level, but there's also inappropriate language. You know, we discussed some of it yesterday in executive session that was used. So I don't want educators to think that, well, I didn't create a hostile environment. I was just hostile. I was abusive, but it didn't create an abusive environment. So I don't have to worry about it. I want to send the message that any type of hostility, intimidating, abusive, offensive, oppressive, inappropriate language or conduct is a violation of conduct that we require of our educators. That's the title of this section. That's the standard that I want to hold our educators to.
Can I ask a question of Ben?
Sure.
So these are all under the may nots or required conduct, I'm sorry, shall take appropriate action to mitigate. But so there are things that teachers, they're supposed to do. But there isn't a specific consequence or is there a specific consequence for violation of one of these? Or is it more just not, and I'm trying not to load this question to you. I want to see it. If we're saying these are things teachers should do, I tend to agree with Joe. If there are more draconian consequences or more, that's why I don't like determinative sentencing, but
This would fall under the general presumption for just any other violations of standards unspecified. So it would be a letter of warning.
more general behave this way kind of language
Yes.
is what and yes, of course we want them to be appropriate. I feel like Joe's might be erring on the side of believing educators. I shouldn't put words in his mouth. I'm erring on the side of believing that educators understand that that's what their job is. And I don't feel like words like appropriate are necessary. I think they're kind of insulting. But given that there's no specific penalty attached to it, I don't think it's worth arguing about. So do you want to make your motion? Your motion's made? Do we just,
Yeah.
let's just vote.
I want to read it just because there were some changes. Any other discussion to the motion? Seeing none, the motion before the committee is to amend lines 134 through 137 to read as follows. 3, take prompt and appropriate action to stop, mitigate, and prevent harassment, hostile, intimidating, abusive, offensive, oppressive, inappropriate language, or conduct. All those in favor? Aye. Any opposed? That motion passes unanimously. Board Member Leader, I believe you said you may have another motion in regard to this rule.
I think I don't have any more on this. I have a few on 211.
Okay, any other motions to 217?
Give us 1 second to scan.
Oh, yeah, please. Oh, okay, thank you. Seeing no further lights, the motion before the committee is that the committee approve R277-217 Educator Standards and LEA Reporting Draft 1 as amended on first reading and forward to the board for approval on second and final reading. All those in favor? Aye. Any opposed? That motion passes unanimously. Let's go to agenda item 2.3. I know we addressed one definition. There are other changes, and I want to make sure the committee has the opportunity. I just want to make, because we focused really on one area. I'm hoping there aren't, but just to make sure, R277-210 Utah Professional Practices Advisory Commission, UPAC definitions amendment. We already did look at this rule and amended one of the provisions. I just wanted to make sure the committee had the opportunity to see if there were any other aspects of this rule that they wanted to address.
I think you
Take a minute or two.
maybe did have one. I'm not sure if I think we mentioned it.
Ben, I still don't like the word informant, but between now and the full board, I'll have to come up with something.
210. We're looking at 210, right?
Yes.
215. Or yeah. 986. I actually had one in 215. Did we do that?
Not yet. That's next.
And we also have then 211.
Yes.
And 211. Okay. I'm great with 210 myself.
I see some people still reviewing, so we'll give it just a little bit more time. Okay, that was perfect timing. But we have it up there, so we'll entertain a motion on 210.
Chair.
Vice Chair Bollinger.
Oh, I better put my glasses on so I can read it. All right, I'd like to make a motion that the committee approve R277-210.
Well, Ben is right. Since we're not making any changes, we did pass this. Yeah. Yeah, so there won't be any motion on that. Thank you, Director Rasmussen. That was my mistake.
This is
Let's
why we
go-
have you. Thank you.
Yep. Let's go to R277-215. This is the Utah Professional Practices Advisory Commission, UPAC, Disciplinary, Rebuttable, Presumptions, and Amendment. And we will entertain a motion, or if questions, staff is here prepared to answer those.
Do we?
One more time, can I get a motion to classify this as exempt? We have a motion on the screen.
Vice Chair Bollinger or Vice Chair Longacre?
Just read them. Sure, I make the motion that the committee amend R277-215 draft 1 to include an oversight category of exempt.
So the motion before the committee is that the committee amend R 277-215 draft 1 to include an oversight category of exempt. All those in favor? Aye. Any opposed? Seeing none, that motion passes unanimously.
I think we've got the same issue on line 42 that was in the other rule. Am I right, Ben, about that?
Yeah, you'll want to change line 42 to mirror the language in 217.
Can we do it that way, just without repeating the language? Can we just say, make the motion to,
And
okay,
you'll amend, okay.
okay.
Yeah.
And then I have one other. Should I go to my other language or which you want me to do first? I got another question or another
Yeah.
comment. Go
Let's
to that
proceed.
one.
Yeah, please.
Okay. Line 86 in this rule talks about reporting. And under line 85, where there's already a standard in law for the requirement for any individual to report suspected child, and it says without delay, and it says if a person has reason to believe. So the standard is in the law on reporting child abuse or suspected child abuse. Under line 86, where this is a new requirement, I have a couple of questions. First of all, I'd like to add, oh, I was thinking about knowingly, but I think maybe that doesn't fit very well.
Can I just make one quick comment? This is not a new requirement. It's just something we've never had a presumption for.
Right,
These are existing statutory requirements that have been in the law for quite some time.
right. Well, but not under the same child abuse reporting standard, right? Yes, exactly.
But the
So,
presumption would be the same.
yeah,
We're just putting a presumption saying that attaching a penalty to the stand.
Understood. Okay, thank you.
oh, okay, I'll just go to my other concern, and that is, because you're reporting to you're not reporting to an authority, you're reporting to parents is what I'm assuming this is meaning. And it doesn't say that. Well, it does say to a parent. I'm wondering if a report includes, it doesn't necessarily mean a personal report. It includes, as we discussed earlier with the requirement to report to parents about physical restraints, if the reporting by email or text, or it would also be a report. Was my so they don't literally have to, someone doesn't literally, teacher, administrator, whatever, doesn't need to literally talk to a person. It includes, we use the word notice
I mean, I think talking to the person is
is ideal.
the best practice, but if they don't answer the phone or you can't get a hold of them, I certainly think texting or emailing would.
I
certainly
don't
be
want an
appropriate.
educator, what I'm getting at is I don't want an educator to have draconian consequences if the educator made 3 good faith attempts and there's the parents didn't learn or claim they didn't learn. So I think hearing you say out loud that report means make the attempt in good faith, then I can live with the word report. But I want to be clear that that the educator shouldn't be punished if the parent doesn't get the information or is hard to locate, or if they got the wrong phone number, or that kind of stuff.
Yeah, if I mean, this is the statute on the screen. There's 2 statutes that apply. I mean, this one specifically talks about informing the student's parents. So I think emailing, texting would certainly meet that standard. There's one other code that imposes this responsibility on an educator as well. So your concern, I think, certainly what you're describing certainly meets the intent of the law in my view.
Maybe we could use the words and say fails to inform the parent of threats of. Could we do that? And then that mirrors the language that's in the law.
I think that actually increases the burden on educators, but if that's in the law, then
I think we should use the language in the law, and I feel a little bit differently, but I think they're pretty similar words. So I think if we use the language in the law, then inform is through email, through text, line 86. Fails to inform a parent of, so that would be the change, Ben. Or a text or anything that provides that information to the parent.
I have a substitute motion on this. Can you go back to the law, Ben? Director Rasmussen?
I don't know. I think it's probably more valuable to leave it a little looser.
Can we go back to the law? Yeah. Thanks. I thought it was a dramatic pause. So here the law says we have to address threats of suicide and self-harm, but there's a third provision, or harming others. And that's when we have to provide notice to the parents. Am I reading that correctly? And if that's the case, then I would ask that our line 86 be amended, not only to include what Board Member Lear requested, but also to address that third provision that harm to others be included in what is required. And a Board Member Lear can do that as a friendly, or I can do it as a substitute motion.
I'm thinking, it seems logical if that's what the law says, we want to have the same language. I'm thinking if harm to others ever implicates other students inappropriately, to use the popular phrase. And I think it's fine. I'm good with that. Yes, I'm good with adding that.
Any other discussion to the motion that is before the committee?
Just have a second to read this.
Please.
So in context, it would just be saying a suspension of up to 1 year is presumed appropriate if the educator fails to inform a parent of a student threat of suicide, self-harm, or harm to others.
So Chair, if I may ask
Please.
a context question. So because the way that I read this is for a 1-year suspension, correct?
It's a presumption.
Okay, of up to one. So if there's a teacher, kindergarten teacher, and a kid hits another kid and they fail to report that to the parent, then they could be suspended for up to a year.
Well, I think we're talking about a threat of harm. So I think you're going to go stab somebody, you're going to go shoot somebody. I don't think it's just that a kid hit another kid. I don't think that would be viewed as a reportable offense under this.
Okay, I just wanted to clarify for those reading. Okay, thank you.
Seeing no other lights, we're ready for a motion. And this is Board Member Lear's motion, so.
I move that the committee amend R277-215 draft 1, line 86 to read fails to inform a parent of a student threat of suicide, self-harm, or harm to others.
Okay, the motion before the committee is that the committee amend R277-215 draft 1, line 86 to read fails to inform a parent of a student threat of suicide, self-harm, or harm to others. All those in favor? Aye. Any opposed? Seeing none, that motion passes unanimously. Any other motions on Rule 215? Vice Chair Bollinger?
Chair, just a question. I know we discussed making sure the language from line 42 matched that of 217. Do we need to make an official motion for that? That will be, okay, thank you.
Any other motions on 215? Seeing none, we're ready for a motion on the entire rule. Board Member Hall? Rebuttable.
That the committee approve R 277-215. Taxes Advisory Commission. Rebuttable presumption after one as amended on first. Second final reading.
The motion before the committee is that the committee approve R 277-215 Utah Professional Practices Advisory Commission, UPAC, Disciplinary Rebuttable Presumptions Draft 1 as amended on first reading and forward to the board for approval on second and final reading. All those in favor? Aye. Any opposed? Seeing none, that motion passes unanimously. The next item before the committee would be R 277-211, is that correct?
Yeah. Do you want me to highlight what was changed over last month?
Sure. And that would be R 277-211, Utah Professional Practices Advisory Commission, UPAC Rules of Procedure, Notification to Educators, Complaints, and Final Disciplinary Actions. Director Rasmussen, do you want to cue that up for us? Thank you.
Yeah, thank you. So you may recall that last month we talked about adding some priorities that UPAC investigators could employ to prioritize certain cases over others if circumstances warranted it. There was some concerns about how that was phrased and whether some circumstances were being given enough priority, I guess would be how I would describe that. And there was some discussion with some board members since the last committee meeting, which led us to change the language a little bit. So now you'll see that on lines 117 through 122, there are three circumstances where UPAC investigators shall prioritize the investigation if the circumstances permit. And that's when there's an ongoing risk to students, where we need to expedite the case for a witness, or where there's the presumed discipline would result in a long-term loss of license. There are some circumstances where we still can't prioritize those due to court cases, but in most cases, with this change, we would prioritize those cases. And then the other considerations that we had previously listed would become mays. So the investigator may prioritize an investigation when there's unusual uncertainty for the educator's LEA or community, or the educator is unemployed as a result of the allegations, or if the educator requests expedited consideration for good cause. So those were the changes that were made over draft 1 in draft 2. So draft 2 is what is before the committee now.
I have a comment about that, but I also I have a couple of amendments for that.
Sure. Board Member Lear?
I'd just like you to explain, Ben, why would we have a shall prioritize for that benefits the system or the investigator, and then we have a may if a teacher has been waiting for 1.5 years or longer, and it's only if we feel like it. Can you help me with why one's a shall? It seems like both should be shalls or both should be mays.
Shall prioritize.
What page?
Yeah, line 117 shall prior. Well, I don't know. It does benefit the system.
Ongoing risk to students.
I get what they are. I can read. I just am saying it feels to me like on 117 those shalls benefit the process, the board, also potentially depending on guilt or innocence or findings, that they could benefit the teacher or they could benefit the students. But I feel like it doesn't benefit the employee, whereas the other.
I'd probably defer to maybe some of the board members at the table on that, because I think the board members that we talked to about this felt that those were circumstances that should be given higher priority than the others. And that's why we kind of broke this up into two levels. Chair Carey, Board Member Hall were both involved in those discussions. I don't want to put the spotlight on them, but I would probably defer to them on that question.
Yeah, I think that summarizes,
Are
the
you going to
posi-
articulate it on your own?
yeah, the position that I took. I do have changes in this section as well, that in a way mirror what Board Member Lear is saying in between the allocation. But yes, generally the items listed in 117 through 121 was something that we wanted to see prioritized.
And the may is because teachers who may be very completely innocent still wait a year plus for these kinds of situations to be resolved.
Yeah, and hopefully what we tried to do was not choose between the system and the educator, but students and the system. And so that's why we're saying if an educator still poses a threat, yeah, that should go to the top of the list. The availability of a crucial witness, again, we thought that would benefit the student. So we looked at it through the lens of how do we best protect the student, not educator versus the system.
And one of the kind of qualifications on that, I'm sure that and I almost hate to say this because I don't want it to be changed, but if there's a crucial witness that would benefit the educator, that would also be a shall then. I think that's an important point to make. I'm not pleased with that, but I don't think that there's equal. I think that there's not the same feeling by others, so no point belaboring it.
Well, what's the Board Member Leader to that point on line 126 and 127? I'm concerned that here on line 129, it says, the educator requests expedited consideration for good cause. Then UPAC may prioritize it. Why wouldn't we put that also at the end of line 127? That yes, the LEA says this creates unusual uncertainty for the LEA, but what if the educator says, well, I don't want it prioritized? Do they get the same deference that they would if they requested it?
I'm not understanding your.
And neither
point.
is Ben, because I can tell by the look on his face. So
I'm just trying to think of what circumstances there would be that the LEA wants us to speed up an investigation. I
So
can't
you
think of
can
a
do
case
their
where
work for them.
I'm not saying that the LEA wouldn't, but I can't think of a circumstance where the LEA would say speed this up, but the educator would say no, we don't want to. The
Yeah,
educators usually want us to move it faster rather than in most circumstances. So I think they both have equal weight under this, and it allows us to prioritize those when we get requests and when we think it's warranted.
but if it doesn't happen that frequently, what would be the harm in saying the educator should be able to weigh in on the request by the LEA to expedite?
Well, I think 130 allows for that. I don't think they're mutually exclusive.
It's only a may. 130 is only a may. So if the LEA objects too loudly,
I don't think that any of these conditions on 117 through 130 would preclude us from taking into account what the LEA has to say about whether that applies or what the educator has to say about that, whether that applies.
well, I think the shall on 117 certainly.
But we can take anyone's opinion as to whether that factor is out there.
So it's not really a shall.
But if that's the case, then why have anything I'm sorry, Board Member Lear, this is your time. and I
We're just
keep-
kibitzing. It's all right. I was just as bad.
But if that's the case, then why have any of the items listed under shall listed? Because if your position is, well, we can take all that into consideration, and we do, but we're highlighting this, so why wouldn't we put in that, yes, in addition to weighing what the LEA is saying in line 127 and 128, why don't we just add a provision at the end that says this request shall also be considered, based on the educator's showing of good cause as to why it shouldn't be expedited. And again, I don't know if there's ever a scenario where that happens. I don't sit in all the UPAC meetings. But again, the educator also deserves certain due process protections, in my opinion, more so than the LEA. But if you're saying it's unnecessary, I'll defer to.
I now understand your point. You're distinguishing between the LEA and the educator.
Yes.
I didn't understand that distinction. I'm, in the spirit of discussion, I'm wondering if what Ben is saying is, because it says the investigator shall prioritize. Prioritize is a judgment call anyway. So it's almost, it seems a little counterintuitive to say shall prioritize, because priorities could move up and down even based on the shall. So to me, I think that's what I appreciate that you're saying you would weigh those factors and would not, just based on one of these factors, do things. You would still weigh, there's still a weighting that you would give to it. And I'm okay with that. I just think the shall is misleading. And you need a verb in there that goes along with prioritize. So, and nobody's going to like may because it sounds too weak. So I guess we're stuck with shall, understanding that there is a certain amount of judgment involved with prioritizing. That's the convoluted way of making sure I understand. Is that right? That's what I think you were trying to say to Member Carey. Is that right? Or did I put words in your mouth?
I don't know if I'd go that far, but
Okay.
you're probably close.
So Ben, it was like we're tag teaming you, but on line 130, are you saying that in your experience with UPAC, there's never been a scenario where the LEA wants to expedite and the educator wants it to go slower? Because if that's the case, I won't make the motion.
I can't think of a
I
case where
can't
that's
think of a one.
been a
Okay.
happened.
When it takes what the time it takes right now for educators to, then they're under a great deal of stress. And if they, depending on the circumstances, usually can't take jobs or apply for other jobs, there's no reason an educator would want.
The tough thing is that we don't get very many, nobody ever requests for us to slow the case down. Everybody just tells us to speed it up.
Okay.
The board tells us to speed it up. The legislature tells us to speed it up, make rules for it. And, this was my best attempt to kind of make a rule to say, well, we'll try and give some priorities, because it's just unrealistic to say we're going to speed up every case when you're not giving me any more resources to do that. And so I will fully acknowledge this is an imperfect attempt to comply with the legislature telling us to make rules. It's very hard, kind of a tough balance to walk.
Understood. And based on that feedback, I won't make the motion I was considering making. Thank you. Vice Chair Bollinger?
Yeah, thank you, Chair. If I may, I just, for me, when I look at this, it's more of, we're going to prioritize these egregious situations that are going to impact. That's how I read it, without all my legalese and all the detail in the wordsmithing. So just for what it is, I kind of understood the intent of what Director Rasmussen was saying. So it helps me know a little bit more of what's going to have a greater prioritization than the others. So just my 2 cents.
I have 2 or 3 other questions. Nothing that I want to amend. I just would like to have a explanation or discussion. I don't mean to be, I just want more information. Line 101 talks about, and it's not new language, the investigator shall prepare an objective and independent investigative. And by independent, I'd like to hear what you believe that is independent of.
Board independent of the schools. Outcome. I mean,
And,
just present the facts to UPAC.
and this is the investigator.
And let UPAC make its call to make a recommendation to the board.
And that would be, the investigator brings to you the information independently gathered and not overly persuaded by, and I know you're the director, but still that would be the investigator's independent conclusions about what should happen.
Yes.
Okay.
Wait, independent of the director? Is that what
Well,
you're?
that's, he can modify them when they get to them, but she's,
Understood.
and now she's empowered to bring to him her independent conclusions. And I just think that's an important piece of it. Line 149. I just had a question. This has to do with expedited hearings. I was just, and it's late last night, so if I read it wrong, the executive secretary shall hold an expedited hearing within 60 days of the criminal court disposition. So is it the 60 days you're focusing on, or is it just you're trying to follow the criminal court disposition? What was your emphasis there?
Well, it's 60 days after they plead in court, within 60 days after they plead in court, basically.
Okay, and that's not new.
Well, we tried to do it before. We've tried to do it before then in the past, but the attorneys always obviously just want us to wait until the criminal process has taken its course before they let their
And that makes
clients
sense.
talk to us. And so
That
that's why
totally.
we're recommending the change.
Yeah, yes, I'm glad I said it was late at night. Thank you. That's really helpful. And then line 197. Next hearing panel should conduct the hearing and include the following individuals where possible. And to me, those all seem very essential parties. Well, an administrator, not so much. An administrator maybe. What's prompting that where possible?
Because it's basically, we invite all these people, but sometimes the administrator doesn't show up. And so we're not going to cancel the hearing just because
Okay.
the administrator doesn't show up. Oftentimes with the administrator, we'll talk to our attorney beforehand and just just allow our attorney to proffer the LEA's position. We're obviously not going to hold the hearing if the educator isn't present.
Good.
Or if the educator's attorney isn't present.
And I didn't
I mean,
think you would, but I was just wondering who was the party that wouldn't show up. And it's not a party, but a extraneous.
Primarily
individual.
focused on.
It's sometimes the administrator. That makes sense. And finally, on line 290, a statement, let's see, this is Pren B, a statement that the respondent admits or does not contest the facts recited in the proposed consent to discipline. That sentence doesn't make sense to me. A statement that the respondent admits or does not contest the facts recited in the proposed consent to discipline.
So this,
Okay,
yeah, that's just when an educator's agreeing to their discipline, they have.
and
to
they won't
either-
contest the
They
facts.
either have to admit it or agree not to contest
And
it.
so you're taking out the as true.
The as true there, I just didn't feel fit. I didn't think it read well there.
Okay, that makes more sense. Thank you. Those are the questions I had.
Any other comments or questions about R277 to 11? Take a minute or two. Seeing none, we're ready for a motion on R277-211. Vice Chair Bollinger.
Thank you, Chair. Would like to make a motion that the committee approve R277-211, Utah Professional Practices Advisory Commission, UPAC Rules of Procedure, Notification to Educators, Complaints, and Final Disciplinary Actions, Draft 2, on first reading and forward to the board for final approval.
The motion before the committee is that the committee approve R277-211, Utah Professional Practices Advisory Commission, UPAC, Rules of Procedure, Notification to Educators, Complaints, and Final Disciplinary Actions, Draft 2, on first reading and forward to the board for final approval. All those in favor? Aye. Any opposed? None. That motion passes unanimously. Is there anything that we missed, Deputy Nui, Sybil? Okay, and just a reminder to the board, we will be scheduling a meeting to review Board Bylaw 4. And when that is scheduled, I've asked staff to coordinate with us for our availability. And then we will go up to capacity of 7 board members when that's scheduled. Okay, thank you. Oh, one final motion.
To adjourn.
All in favor? Aye.
That turned out pretty well. I know.
So, you know,
That's fine. 1 o'clock.
wait, hold on.
This is council.
Yeah, right.
So what?
Then we have our, US or US. This is how I organize mine, because when I go, when I do this is the meeting and this is the.
I have a question.
After I listen to all of the things, right, and this finally comes out, I go to, like, if you click on the